Appeals, First Appellate District of Ohio, with the Honorable Candace Krause presiding, and now please be seated.
Good morning.
Good morning.
Welcome to the First District Court of Appeals. On the docket today are 5 cases for argument. And I'll just let the parties know if anybody needs a break. We're going to plow through this morning, but if you do need a break, don't hesitate to ask, and we can break between cases. So just to get everything straight of who's arguing what and what cases are on the docket, I'll go through the cases. The first case up for argument is case number C-22-023 and 37, and that's Green versus Durrani. I have Mr. Sayer.
That's correct, Your Honor.
For the appellant, and Mr. Winter for the appellee.
That's true.
Okay. And then the next case is case number C-22-0024 and 034, Potts versus Durrani. I have Mr. Williamson to argue for the appellant.
Right, Your Honor.
And Mr. Winter for the appellee.
That's true, Your Honor.
And then C-22-0025 and 033, McCain versus Durrani. And that is also Mr. Williamson for the appellant.
Correct, Your Honor, if you don't mind, we'll have a short break between those two to just sort of turn the binders over.
Yeah, no problem. That's not a problem at all. And then Mr. Winter again for the appellee. You had a busy morning.
3 of them and only 1 of you.
I know. You need to get more manpower over there.
They're gunning them.
I know. And then case number C-22-027-032, we have Stratman versus Durrani. This one we have Mr. Herzig for the appellant and Mr. Winter for the appellee. And then our final case today is C-22-0350, Nichols versus Durrani, and that is Mr. Sayer for the appellant and Mr. Winter for the appellee.
Yes.
Okay. And I was informed by our court administrator that you all wanted to address an issue that with the collage that is kind of throughout many of these cases. So whoever would like to address that.
Go ahead.
Sure, Your Honor. Probably less of an encouraging update than you would like. But what we figured out is there are 2 versions of the collage that have been played in the cases that you've heard. There's the short, sort of 50-minute version, which I think is the version that all of you have seen at this point. I would describe as still out of bounds. Then the 80-minute version is the one that contains more of the, we'll say, far more out of bounds information. The textile business in Pakistan, Saudi royal family, kind of that kind of paragraph of stuff. I have been in conversation with plaintiff's trial counsel. They are looking for the 80-minute version of the video, so we will happily supplement the record with that as soon as we get it. I can tell you the short version, the version that you all have seen, was played in Stevenson, Stratman, and Nichols.
So I'm not convinced that's accurate, because when we were reading the transcript in Stevenson, there was a comment that this video that's about to be played is 1 hour and 20 minutes. And so I would, obviously we have no idea what was played, but I would encourage you all to cross-reference what's in the transcript right before the video is played to confirm the accuracy of that, to make sure we get the right thing. Now, maybe counsel was wrong about that, but it just was unusual to me that he said 1 hour and 20 minutes, not it's about 1 hour or something.
Right, Your Honor. One of the difficulties that we have run into with the collage, and I perhaps should let plaintiff's counsel speak to this a little bit, is that basically in a number of these cases, because it's a video, for most of the video depositions, the court reporter is sort of released to leave the room. On the theory, it's video, we already have a transcript of it, so she doesn't need to be in the room to take it down. As it turns out, in not all of these cases, is the transcript getting filed. In many cases, you have objections being ruled on sort of shortly before trial or shortly before the video is played. And I think, as you've noticed in the record in these cases, the video then just doesn't get filed in the record, and it seems not left with the court. which does create a record problem, say on the defense side. It's not our exhibit, and it's not in our possession. And so we thought that it was being filed in these cases. It turns out that it hasn't. Like I said, we're talking to plaintiff's counsel to get a copy of the video for the court's reference. But in the interim and in the absence of that, I think you'll notice much of what we have relied on has been the trial court's description in post-trial motions of the statements contained in that exhibit, and we're, as the appellate guys, in a certain sense, trusting the trial court, even in cases where we think the trial court's judgment was wrong.
Okay, all right, so you're working on supplementing, and it's gonna, every case has to be supplemented, so you're gonna, I mean, we
Correct.
wanna have a complete record, so I know this is gonna be kind of a lot of work for you guys, but otherwise, we're not gonna have, you know, there's some cases where there's a transcript or no transcript, there's no video. We need each case to have the right transcript and video.
Absolutely, Your Honor.
Okay,
I will spare you one. The collage was not played in Potts.
Right.
It's actually a different deposition. So there's at least one that we can all be reasonably confident in.
right. Okay, well, thank you for the update, and we'll just wait to get the supplemented record when you get it.
Thank you, Your Honors.
Okay. Okay, so we're going to be starting with the Green case. Mr. Sayer, would you like to reserve some time for rebuttal?
Yes, ma'am. I'd like to reserve 3 minutes if I could.
3 minutes, and I'll be working the lights on the podium, so when you have about a minute left of your initial time, the yellow light will come on. And then, Mr. Winter, I believe this is a cross appeal. Did you want to reserve time?
Yes, been my practice to reserve 2 minutes.
Okay, you guys are making it easy on me. Do the same thing every day.
With the permission of the court, may I have my stopwatch?
Absolutely.
with me?
Yes. Whenever you're ready.
Okay, thank you, Your Honor. Good morning. May it please the court, Russell Sayer, this morning arguing on behalf of the appellant and cross appellee. I know from yesterday I was here that we're seeing some of the same issues arising in more than one case. We're going to see that today as well. Well, let's start in Green with something completely different. This surgery was a success. Ms. Green was in generally poor health and had back and severe leg pain for many years before she saw Dr. Durrani. Non-surgical therapies had been unsuccessful, and she declined Dr. Durrani's suggestions with respect to non-surgical intervention. And her surgery, after her surgery, her leg pain, which she had described on a scale of 1 to 10 as a full 10, had improved or perhaps even completely disappeared. And despite that successful outcome, the jury here returned a $1.8 million verdict. We talked yesterday, or the court talked yesterday, about close cases.
Well, counsel, hadn't her condition significantly declined? I mean, at the time of trial, she was living in a nursing home. She wasn't able to walk or effectively use the bathroom. Her son testified about her decline in functioning.
We don't have any medical records for that period, but what we do know is that 6 years before, she had undergone successful surgery that alleviated the pain in her legs. Ms. Green, unfortunately, was in very poor health, morbidly obese. She was diabetic. I don't think it's outrageous to think that, health problems follow those sorts of conditions. And it's not surprising, at least to me, that after 6 or 7 years, those sorts of things will continue to catch up with you.
Isn't
So
this, I'm sorry, go ahead.
We don't really know that her current condition was caused by Dr. Durrani's surgery.
No.
Well, and on the question of like the future economic damages, there was testimony, I believe, about like what the nursing home would cost. But the question that I had was, is she in the nursing home because of issues related to the back pain or for other reasons? And how do we know like what charge would be associated with back pain related issues or surgically related issues versus something other?
Your Honor, with the passage of so many years, I think that's the answer to that question is simply unknowable. She is certainly confined to a nursing home. She certainly has serious problems, the sort of serious problems you would associate with both age and poor health. And we do know what that testimony was, but what we don't know is how you parse the source of the injury or the source of the pain. What we do know is that for the 6 or 7 years that elapsed between the trial and, or rather between the surgery and the trial, we don't have any medical records.
How do you not have the medical records? I mean, surely you ask discovery on that.
We have no medical records from Ms. Green during the period from the surgery to her trial. Those medical records possibly could have enabled us to parse what was associated with a surgery and what was simply associated with age and obesity and diabetes. We just don't know. The record doesn't reflect it. And we don't know why it wasn't produced in discovery. It wasn't, and it's not part of the record.
I thought that she suffered from some sort of nerve injury that was a complication of the surgery, and that's kind of what was causing her problems after the surgery.
It's undoubtedly true that there was a known complication in the surgery, and that was the nick of the nerve in the spine. When I say known complication, I'm talking about something that physicians over the years have determined is, if not likely to happen, going to happen with some frequency, in this case about 30% of the time. With known complications, it is not generally thought that you associate that with medical negligence. It's just something that happens. But to your other point, Your Honor, there was also a post-surgical infection that was successfully dealt with. So after the surgery, yes, there were undoubtedly the pinched nerve or the nicked nerve was still an issue. But when you get right down to it at the bottom, she had significant improvement in her condition and the pain after the surgery.
So the nerve caused her issues with walking, but you're saying that the pain was alleviated.
That's what she said.
Okay.
Yes. Yeah. So as I was saying, this surgery was a success, and yet we have a $1.8 million verdict. How did that come to pass? We heard comments from the bench yesterday about close cases. And let's say a successful outcome in this case might count as a close case. What might have tipped the scales? What might have influenced the jury? And this, I believe, returns us to the now infamous so-called collage. And in this case, I believe we're dealing with the long version, which the court has not had an opportunity to review, as I understand it. We recognize that the way the collage was handled below was perhaps not as careful as it might have been, and that this part of the record continues to be somewhat murky, to the point where it's not altogether clear in some of these cases what version of the collage was actually displayed to the jury, and Judge Bergeron pointed that out just a few minutes ago. We would say that the admission of the collage was error, all of it. And from the colloquy yesterday, it's clear that the court has some skepticism and concern about that, or at least about some of what we know was in it.
So let me ask this question, and this may kind of retread some of the ground from yesterday, but I was thinking back on potential impeachment value of some of the questions and looking back at Rule 608 and 609 and thinking about like questions probative of truthfulness can be appropriate impeachment questions. I mean, there are parameters, and I hear what Mr. Winters is saying is that like this is all going to character for truthfulness. So how do you respond to that?
Well, the character for truthfulness. We talk about impeachment typically in terms of impeaching testimony. The witness testifies in a particular way. He has said something inconsistent, or she had said something inconsistent or different at some time in the past, and that is perfectly fair game. You can impeach with that sort of thing. You can impeach the truthfulness of a witness based on crimes involving dishonesty, robbery, burglary, that sort of thing. Here, though, it's curious because we don't have any testimony really to impeach, or at least no testimony that's relevant to Ms. Green's case. What we have is...
But I don't think it has to be relevant to her case. Like, think about, like, you're convicted for fraud, then that might implicate your propensity to testify truthfully on the stand. And so I think, like, some of the questions about, like, did you mischaracterize your resume? Did you do things like that? I don't know where those fall, but I think that's where they're going.
I think a good place to draw the line there would be a judicial or jury determination that someone had in fact committed fraud. One of the panel yesterday pointed out that Dr. Durrani didn't recall or had no information on many of these questions, which were leading questions, which essentially counsel testifying in the form of leading questions, with respect to which the factual predicates are unknown to us. We can't test them. We don't know them. They're essentially the declarations of counsel. Isn't it true? Isn't it true that you falsified your resume? Isn't it true that you beat your wife? That kind of thing. And that gets me to just what kind of impeachment are we talking about here, Judge? We're not talking about impeaching anybody's testimony. What we're talking about here is impeaching Durrani's character. And it's a very different thing. What you're doing is attacking the man and telling the jury that this is an unworthy individual, somebody that perhaps deserves to be punished, if not for this, then for something else.
You can explore, as Judge Bergeron was saying, you can explore instances where he may have been untruthful in the past, right? I mean, it doesn't necessarily have to be impeaching him on specific to this case, but it seems like what they were trying to get at was you had a sworn application, you omitted certain information, that kind of stuff. You can do that, right? I mean, that's not an issue. You're just taking issue with how it was done.
Yes.
Okay.
Yes. And just to take your example, if he's asked, if Dr. Durrani was asked if he misrepresented or omitted something from an application or a form somewhere, I don't believe that the record indicates that Dr. Durrani admitted to that, but counsel for the plaintiff assumed it was true and repeatedly and badgered him about it, and the jury saw all that and undoubtedly assumed it to be true.
Well, I guess there's also a question in my mind, like, is the analysis different given that this is a deposition that we know what the answers are versus if someone were testifying live and you don't know what the answers to those questions are going to be? Because you might allow those questions, but here we know what the answers are.
Well, yeah, you might allow the questions if the court might allow the questions if the questioner were to verify the factual predicates, but that wasn't done here. So we don't even get to the second part of your question. These are statements, essentially allegations that were in most cases either denied or not recalled or the witness didn't answer. But the questions stood. The jury heard them. The jury heard about license revocations. The jury heard about a domestic violence charge that was dropped. The jury heard about the revocation of hospital privileges. The counsel made sure that the jury remembered other cases in which Dr. Durrani had been sued for malpractice. With the factual predicates, as I said before, murky at best, this is really a case of as I said before, the plaintiff's counsel testifying in the form of questions.
Counsel, is there any purpose that you can think of that is permissible under the evidence rules to admit Dr. Durrani's testimony that he does not recall being sued for medical malpractice or that he does not recall submitting falsified research while he worked at the Scottish Rite Hospital, for example?
As I stand here now, Judge, no. The collage, the video, is really just a litany of allegations being hurled at Durrani over video across thousands of miles. and counsel expecting complete, thorough answers that Dr. Durrani, I think quite plausibly, was not in a position to respond to. But for whatever the reason for his answers, perhaps they were evasive. Perhaps he wasn't being truthful when he said he didn't remember. We don't know, but we don't even get there because nobody has established that the allegations that were being made and he was being asked to endorse were themselves true. We just don't know.
And you are at your time if you want to reserve rebuttal.
Oh, I'm sorry. Yes, I would like to reserve rebuttal. Thank you.
Thank you.
Well, we hear so much about the Durrani collage here, and didn't do us much good this time because there was no finding of liability for informed consent, no liability for fraudulent misrepresentation, battery. The only thing that we had a finding of liability on is negligence.
So you're saying that the collage would be harmless in this case?
Where's the harm? Assuming it's evil, shouldn't be admitted, shouldn't be considered, nothing happened. The jury found, excuse me, the jury found that Dr. Durrani failed to meet the standard of care. And that was the only thing that we had that happened to Dr. Durrani.
Now, can we tell from the interrogatories what the jury found? I mean, was this the operation wasn't necessary, or did this have something to do with the complications that occurred during the operation?
I think that they didn't discuss very much or find fraudulent misrepresentation, that it wasn't necessary. Dr. Bloomfield, Dr. Siani, and testified that the surgery wasn't necessary. That the jury just found, and I just read it, that they failed to use, Dr. Durrani failed to use the standard of care. Okay. There was. Yes, sir.
The question about the future damages, it troubles me that for whatever reason, her more contemporary medical records were not turned over, and then you have an expert who's opining that, like, well, she's going to need this care going forward. But, like, what's the basis for that opinion of the expert if we don't know what care is she currently receiving and what is the reason for that care? In other words, how do we know that the care that he is suggesting is caused by the negligent surgery?
She has a lot of complications arising from the surgery. I don't know what's wrong with my throat. I apologize.
You can get some water if you need.
So was it complications that were, that came out of the nicking of the nerve?
Yeah,
Is
the
that-
phenomenal nerve.
Is that what
That's part of
they
it.
were
She
saying?
falls down a lot. She has to go into the nursing home periodically. That didn't happen before the surgery. Her son testified that, and Dr. Bloomfield testified that she suffered permanent physical functional injury that prevented her from being able to care for herself and perform life-sustaining activities. I've outlined all those in my brief, or attempted to, and
But why, like, I guess I just don't understand, like, in a typical case like this, you would expect the medical records to be produced to show what care is she currently receiving and how much does that cost. and then your expert would opine that she needs this care, it's going to increase, it's going to decrease, whatever, but it would be based on the medical records. And like here, that's not, I don't understand why those weren't produced.
I do not know the answer to that, Judge. All I can say is probably the short fuse and timing of in litigation. There are a lot of these going on, and can I speculate that it's slipping through the cracks? That's happens from
Okay.
time to time. Maybe even happens in this court. I don't know. But that's the best I could do, Judge. They normally, I'm involved in some of the trial in federal court, and I know that those records get turned over. But sometimes my opponent calls up and says, Bob, where's, and we get it over. But I can't state what happened here.
Okay.
That's the best all I can do is that state that she'll have, this the future, she'll have the surgery, and she'll have a lot of nursing home time, and that didn't happen before the surgery. Yes, ma'am.
Did any expert testify that her need for nursing care was linked to the nerve damage from the surgery?
If they did, it came from Dr. Bloomfield. And I can't quote book, chapter, and verse, Judge Kingsley. That's where it would be. I'd be surprised if it didn't, but a lot of these cases are surprising.
And does it matter if she needed the nursing care at the time of trial or if she needed it just after the surgery at any point?
After. There may have been nursing, I believe Anthony Birch testified that she had been in the nursing home, but not with the frequency that we had after the surgery. I thought he was pretty clear about that.
All right, so
I would refer you to him to give you that piece of the puzzle.
so her son supplements the expert's opinion?
Yes.
Thank you.
I'd look to that. One thing I'd like to, two things I'd like to talk about the collage, if I may, for a few minutes. It was, I'm told that Honorable Alan J. Statman and Michael Lyon met for a lengthy period of time with Judge
Schweikert?
Yes, you win, thank you. And they had a lengthy period of time and went question by question. And things were discussed, and objections were overruled or sustained, and that's where we got to where we are today.
We see some references to that meeting, hearing, whatever you want to call it, in these cases. People talk about that having occurred. But I do not find a transcript of that
And you're right.
hearing anywhere.
You're right, and what happened is everybody then was governed by the outcome of that meeting, for better or for worse, and that meeting's never got into any future records.
Do we know if that, that hearing, let's just call it the Schweikert hearing, if that occurred in any particular case, or was it for all cases? Do we know what it was set under, like what case number it occurred in?
Well, I wrote down, and I'll get you a case number and find that out.
All right, because it occurs to me that it might have happened in a case number that, for whatever reason, did not get appealed, and therefore it was never transcribed, and therefore we've never seen it. And it would be extraordinarily helpful to us to see what happened in that hearing.
I'll see if there's anybody took the meeting down, or if there was any meeting notes that came out of it, and I'll give them to appellant's counsel and then complete the step.
Thank you, that would be very helpful.
Yeah. Ask Mike Wine if he has anything. All right. The next point that I'd like to, I didn't think I was very persuasive with regard to the collage. Let me try it again. Medical records came in from Dr. Durrani and Cass's offices. We say that the records were bogus, or they stated truthfully that Dr. Durrani's exaggerated findings. Anyway, it created something for a jury to decide. They come in under Evidence Rule 806, as I understand it, and 806 allows us to attempt to impeach or cross-examine to the extent we can. We have a bad act 404B issue arising here that we've talked about yesterday.
What is the 404B purpose? So 404B enumerates some specific purposes that,
allows it, and
what is yours?
absence of mistake. Absence of mistake. There was,
What's the claim of mistake here, and how does the collage show the absence of mistake?
the collage shows that Dr. Durrani, if he were here, would say, there's nothing wrong. There was no, everything was copacetic, everything was right.
Yeah, but saying that I performed the surgery appropriately and that was the correct surgery to perform is not, that's not a mistake issue.
And the lead up to it. I mean, I looked at that Hartman case that was.
Yeah.
Yeah, I mean, that seemed pretty good to me.
Well, but Hartman is really clear that, like, what would happen previously, both in civil and criminal cases, was counsel would just say, oh, it's one of these, and the trial court would say, okay, that's fine. And what Hartman is saying is, like, no, you have to show more precision, and we have to identify what is the actual purpose, and just kind of pointing to this, group of potential criteria is insufficient. So what I'm trying to understand is where is how the absence of mistake fits in this situation.
Well, Dr. Durrani and my opposing counsel at trial said there is no problem with these records.
Wouldn't he have to admit that he made a mistake, and then you would put in information to show that he didn't?
Well, we would say that there's plenty of mistakes.
Okay.
I mean, and our.
But he's never saying that he made a mistake. So you're saying you're putting in information to say there's an absence of mistake?
What we're saying is that, well, Dr. Ronnie would say what he said in his records. He says that they're truthful.
Mm-hmm.
We say, no, they're not truthful. And in various ways and methods that Drs. Wilkie, Ciani, and Bloomfield have testified to. Okay.
I think what Judge Krause is saying is that for the absence of mistake criteria to apply, a witness has to say, oh, that was a mistake. And then you bring in the evidence under 404B and say, that's not true. Like, here's 5 instances in that exact scenario where that witness did the same thing, and it was purposeful. That's my understanding of how that aspect applies.
Well, Dr. Durrani would say there is no mistake.
Right, but that's the problem. Like, he needs to say first, I made a mistake, or I was mistaken, for that aspect to apply.
But he would say, well, you know, he would say, these are truthful, these are proper medical records. And we're saying, no, it's not in various ways that my experts would say. And this is, you've been doing these types of things in the past under oath, and we've been through the laundry list. That's where I'm coming from.
And we did take you over your initial time with questions. If you want to reserve 2 minutes, you're at your time.
Can I say 2 minutes?
If you want to use your 2 minutes, you can use them.
Well, I've got to say something about the set-off. I don't think I have Adams to help me out on this one because there's no intentional tort. But they're still not entitled to a set-off because under the statute, in order for them to be entitled to a set-off, there has to be, they have to be joint tortfeasors. And UC and Westchester Hospital are not joint tortfeasors with Dr. Durrani and Cass. We're familiar with what the claims are against, and the judgment are against Dr. Durrani, but the claims against UC and Westchester are negligent credentialing under the negligent credentialing statute. In that Evans case,
But
Brown-
didn't you also sue them for vicarious liability? I mean, I'm just going from memory here about all the cases against the hospitals. I realize there were negligent credentialing, but I thought there was also,
if you'll give me a second. I think not, but
okay, I could
I've
be
been
wrong
around.
about that.
You've told me many times I'm wrong.
So you're saying they only settled a negligent credentialing claim?
There was a
in
negligent
this case.
credentialing claim asserted by all my folks, including Gloria Green, against Westchester Hospital for credentialing Dr. Durrani. There was
If
fraud.
we interpret these rules,
I'm sorry.
if we interpret these set-off rules to require complete unanimity of claims, don't we encourage plaintiffs to include some bogus, non-unanimous claim?
Here's the thought.
Or to structure settlements in such a way as to avoid set-off and create a windfall for themselves.
I think in this instance, no, because our claims against Westchester and UC are a matter of public record. And though negligent credentialing cannot be asserted against the appellants here. Just can't be.
But couldn't you sue parties for a wide swath of things, as you did in this case, and then settle with a particular set of defendants on some claims and dismiss others as part of that settlement?
We should dismiss them all. I can't imagine counsel UC let me get away with that.
Well, sure. But for the purpose of creating an in-run around these set-off rules, I mean, aren't you really parsing the joint tortfeasor definition to avoid set-off in essentially all cases?
That's what the General Assembly says they have to be joint tortfeasors. That statute's purpose is to change the common law that was, there's no contribution among joint tortfeasors. Now there are. Now there is, whatever the verb is. There is now.
But as I look at page 36 of your brief, you say the claims against UC were of two varieties: intentional torts, fraud, negligent credentialing, spoliation, et cetera,
Yes.
and unintentional torts, which you don't elaborate, but I take to mean negligence.
I think we had a negligence, yeah.
Well, then there's an overlap there.
No, sir, because the negligence of UC towards Ms. Green is different than their negligence towards Ms. Green.
Then why was it in the same complaint?
I'm sure that I would get, if I filed 2 suits, there'd be some defense attorney that would be pretty creative to say I should have put them all in one suit. I get that all the time, Judge. So put them together, joinder of parties, and
So convenience.
I'm not saying they're and one point, we don't know how the Adams issue will shake out once we settle with UC. I mean, their clients may have been hit for intentional torts, in which case this backup argument, not backup, but this joint tortfeasor argument is, I don't have to make it because Adams does the work for me. And that's the way it was in Judge Bergeron on that question you asked me yesterday. Adams does the job. Well, yes, it does, but so does the .25 statute. They have to be joint tortfeasors. Where we see tortfeasor in that statute and in .28, it's joint tortfeasors. And these folks are not joint tortfeasors.
Thank you. You are at your time unless my colleagues.
Oh, I'm sure I'm well past my time.
You are
Thank
well
for your-
past your time.
Thank you for your patience.
That's all right. That's why we're here. Mr. Sayer.
Thank you, Your Honor. I will, of course, confine myself to rebuttal points unless the court has questions that it'd like to explore.
I
with
do
me.
have one question on the 404B issue.
Yes, ma'am.
Your brief cites Hartman, and we've had some discussion of Hartman. Hartman was decided after this case went to trial. So can you discuss whether the case is retroactive and would apply here?
I believe that the case would be retroactive and apply here because the court in Hartman is simply articulating what the rule always was and what the rule, how the rule should be applied. But while we're on Rule 4, if I've answered your question sufficiently, while we're on Rule 404B, the purpose of Rule 404B is to eliminate prejudice but allow impeachment. Impeachment, proper impeachment, would come up in a situation in which the doctor testified, quote, "I made no mistake," unquote. Now, if there was testimony in a sworn testimony in another deposition, "I made no mistake," then that would be a perfectly appropriate reason to impeach the witness. But that's not what happened here. The Ohio Supreme Court tells us that the bedrock principle underlying Rule 404B is to protect defendants because the typical juror is prone to more readily believe that a defendant committed a wrong if it's proved that the defendant did something similar in the past. None of the excerpts from the expanded collage do anything to tell us about Ms. Green's treatment, and they don't tell us anything about anything that Dr. Durrani did with respect to his treatment of Ms. Green that had anything to do with something.
What about Mr. Winter's point about absence of mistake? And was my articulation of that accurate? How does absence of mistake apply here, or does it?
I'm not sure I understand the question. Absence of mistake?
He was arguing that this comes in through the 404B exception for absence of mistake. And I was pushing back on that and asking whether absence of mistake applies in this circumstance. So I was curious as to your perspective.
I don't think it even matters because we don't have a situation in which one could argue that the testimony in the collage argues an absence of mistake. And we don't have any testimony from Dr. Durrani that the collage would call into question. What we have is testimony about license revocations, testimony about the domestic violence incident, testimony about the hospital privileges, testimonies about other medical malpractice cases. None of this has anything to do with the treatment of Ms. Green, but you can readily surmise, Your Honor, how important that was to the plaintiffs because those things weren't just said in the collage. They were strewn throughout the record, throughout closing statements. And if you're curious about how it is that a $1.8 million verdict was entered in a case in which the surgery was by all by all accounts, successful, you don't need to look any further than the collage. One would have to suspend disbelief to conclude that in a case where a plaintiff's condition improved after surgery, that allowing the use of that inflammatory collage was some harmless lapse that could not have influenced the jury. In any case, and to use the court's term, and especially in a close case, one must presume that an error in admitting the collage and allowing counsel to sow the record with repeated references to it could not possibly have been harmless. And it doesn't require much in the way of presuming to see the obvious. The collage does nothing to impeach Dr. Durrani's testimony. There was none about Ms. Green. He didn't testify about Ms. Green. The collage was assembled, edited, and used to impeach not testimony, but to impeach Durrani's character. All of this is inadmissible under 403B, and Setters 1 provides us with specific guidance there. To quote this court, in a medical malpractice case, evidence that a defendant doctor's medical license was revoked is by its very nature prejudicial. It predisposes the jury to find that the doctor acted outside the scope of acceptable bonds of competence. There is the 404B question. The collage used in Ms. Green's trial was inadmissible, prejudicial, and all but irrelevant, compounded by what we know to be an appeal to ethnic prejudice. In this context, the trial court's statement to the jury that it could draw whatever inference it chose from Dr. Durrani's absence was little more than a thinly disguised flight instruction, which we already know would have been inappropriate. You know, Ms. Green was absent from the trial as well, but no comment was made about that. This case has to return to the trial court for a proper treatment of the set-off in accordance with Setters 2. The idea that this was negligence only, so where's the harm? Well, the harm is right in front of you. You've got a successful surgery, nearly $2 million jury verdict, and a nearly $2 million jury verdict. It beggars the imagination. It's difficult to imagine how that could possibly have happened if the jury hadn't concluded that Dr. Durrani, although he might have performed this surgery successfully, performed this surgery well, nevertheless needed to be punished for something else that he had done, for being a bad man, for being Pakistani, for having Arab experts. It's rather distasteful. The court needs to use, or respectfully, the court should use this opportunity to instruct the court below on several issues, this being chief among them, lest they be repeated time and time again in the hundreds of cases that are going to follow.
You are at your time on this one. So.
Thank you, Judge. I think
you.
I actually was indulged with a little extra time.
I'm trying to indulge everybody with a little extra on these cases. Thank you. Okay. So the Green case is now submitted. We have Potts versus Durrani is up next.
Shuffle a little bit.
That is fine.
It's a show of great respect for my esteemed colleague on the other side.
Needs 3 lawyers to go up against him.
May it please the court, I am again Philip Williamson, appearing on behalf of Dr. Durrani and cast.
Oh, I'm sorry. Did you want to reserve the standard 3 minutes?
Yes, please. Thank you, Your Honor. Like Mr. Sayre, I do come to you with something a little different than what you heard most today yesterday. This I refer to as the curious case of the dog who agreed not to bark, but barked anyway. Mr. Jeff Potts was first injured playing high school football in 1981. He had a herniated disc, had to undergo surgery. He had additional surgeries in 1991 and in 1994. He undertook non-surgical treatments, including a spinal cord stimulator, medication, physical therapy, injections, no relief. In fact, by 2010, he was taking oxycodone and such a high quality of Motrin that you would not indulge on a daily basis, but for his level of unrelenting pain. This was just to cope and get through the day. He spent 15 years on permanent disability. all of this before Mr. Potts ever saw Dr. Durrani.
Great, I understand those points, but like the evidence is that he was in significant pain after the surgery. There was the issue with the colon, and I hear the medical history, but isn't that just something that the jury has to sort out? Was his pain caused or exacerbated by the surgery, or was it pre-existing conditions?
Well, Your Honor, much like I mentioned yesterday, a number of the evidentiary questions in this case are going to turn not on whether an error was committed, that much is conceded, but whether that error was harmful. And in this case, you have...
But in this case, it's not like some of the other ones we've been talking about where the person says, oh, I improved, right? This is the opposite.
Right, Your Honor, so the question for the court is whether you honestly think Dr. Durrani did $13 million worth of compensatory damages in this case.
I mean,
and
that doesn't,
$26
but that
million
doesn't
of
matter
punitive.
because that wasn't the award at the end of the day.
Well, in what sense, Your Honor?
I mean, because it was reduced through the tort reform statute.
Well, no, Your Honor, when we're assessing how the jury viewed this case, the number that the jury put on the table does in fact matter.
Well, doesn't
The
that
jury's
suggest,
decision to award, sorry, Your
doesn't
Honor.
that suggest that the jury was highly convinced by this case?
No, Your Honor. This jury, they had their prejudice and their passions against Dr. Durrani inflamed in a number of ways, the most important of which is that Mr. Potts' expert told the jury that Dr. Durrani gave this man breast cancer.
This is another problem we have with the record. When we're looking at this cancer testimony, my understanding is that there was a edited version that was supposed to be played for the jury because the judge ruled that the cancer references were not to come in, right?
Not just the judge ruled, but that plaintiffs stipulated that it would not come in.
Okay. And then accidentally, apparently, well, whatever you want to say, it happened to come in. They played the wrong video, right? And there was one reference made to this cancer.
It's not that they played the wrong video, Your Honor. It's that a part of the video that was supposed to be edited out was not edited
Okay.
out.
But
And
then
we
the
have that
judge,
exchange in the
but
trial
the judge
proceedings.
stopped everything, right? And the attorneys were able to fix it and then play. The rest of the video did not have the cancer references, correct?
Your Honor, I think where I push back is on the idea that the parties were able to fix this.
Well, okay, I understand your argument. Here's the problem. The actual video that was played for the jury, I don't think is in the record. I think all we have is the unedited video with the multiple references to the cancer. So that's my problem. I'm just letting you know.
I mean, I think globally, I don't want to tell you guys how to do your job at trial, but I will. It seems like there needs to be transcripts of these videos done in real time to avoid these scenarios. And I realize, like, easy for me to say, but it's also like we shouldn't be like trying to sort these things out and try to understand what was actually presented to the jury at this level.
Yes, and the videos themselves can also be put on a USB stick and easily entered as an exhibit into the record in every case so that we can see the actual video because it's very difficult for us to parse this out at this level.
Your Honors, I don't disagree with you, but we're not the ones making the call to send the court reporter out of the room. And it's not our evidentiary exhibit. It's in the hands of plaintiffs.
Right, but you're the appellant, so it's your duty to make sure the record is complete. And I realize it's their video, but I mean, look, I'm not being critical of anything that's happened. I realize like stuff happens at trial, and you guys thought this was taken care of. But just from a going forward perspective, I think there's lessons that can be learned from what we've talked about the last 2 days.
Absolutely, Your Honor.
Returning to the Dr. Wilkie deposition and the reference to the cancer diagnosis, didn't the trial court give a curative instruction? I mean, what else could have been done?
Your Honor, granting the motion for mistrial that defense counsel made. There's no curative instruction that's going to address an expert saying the defendant gave Mr. Potts breast cancer. In fact, and as trial counsel pointed out, giving a curative instruction only serves to emphasize that fact to the jury.
Well, then but what you're basically telling us that we're going to have to say that you can't give a curative instruction once the cat's out of the bag. I mean, we have to assume that the jury is going to follow it. And in this particular case, there was one reference to cancer. I think they didn't argue it. The jury didn't reference it in any of the interrogatories. So, I mean, you're basically saying, oh, sorry, the curative instruction never works?
A few points in there, Your Honor. First, we're not saying that curative instructions never work, and we're not saying that you reject the presumption that the jury follows instructions. But there are some errors that occur at trial that a curative instruction can't fix. This is the reason why we have mistrials. And telling a jury the defendant gave this man breast cancer is one of those evidentiary errors that you can't just fix by telling the jury for 2 minutes, ignore what you have heard.
Right, but I mean, like, this has to have come out of left field from the jury. It's not like there was a lead up of like all this stuff about cancer diagnosis and then this expert is connecting these dots. Like I don't understand, like, if I'm just sitting there on the jury and I've not heard anything about cancer, then all of a sudden, I am questioning, like, the impact on the jury versus if this had been, like, part of a concerted effort to skirt the court's orders.
Well, Your Honor, the $26 million punitive damage verdict certainly suggests that the jury thought that Dr. Durrani needed to be punished. To put it in perspective, Your Honors.
How do we know that that came from the cancer diagnosis reference and not from the botched surgery, the extreme issues that occurred after this surgery with the sepsis and the collapsed lung and the colon tear? I mean, how do we know what motivated the jury to issue this very large award?
A few things, Your Honor. First, I think to put things in perspective for the court, the compensatory damage award in this case was about $13.1 million. The total compensatory damage awards for the other 8 cases that you have heard this week is about 14.2. This case is an extraordinary outlier just on pain and suffering alone, much less, again, a $26 million punitive damage
But I mean,
verdict.
also, and I don't say this to belittle the harm suffered by people in the other cases, but it also seems one of the most significant harm suffered by any of these individuals.
So, Your Honor, to perhaps answer both your concern and Judge Kinsley's question. So you do have the issues of sepsis, the perforated colon, which trial evidence will tell you is not particularly uncommon for a surgery like this. Part of the explanation, I think, for the large punitive damage award here are some of the other evidentiary issues, some of the other evidentiary areas that we have a problem with, including but not limited to the loss of license and Dr. Ciani testifying well outside his competence in this case.
Let's get to those. Now, the loss of license, this is another question I have on the record. We don't have a collage in this case.
Correct.
We apparently have a deposition of Dr. Durrani that was played for the jury, right?
Correct, Your Honor.
Okay. The only deposition in our record is a 2011 deposition. But there's a reference to another deposition, and we don't know, that one's not in the record, so we're unclear of what deposition was played.
A fair point, Your Honor.
Yeah.
Just
to let you know.
I'll point out in our briefs, the deposition is not the only place where this comes up. This shows up from the beginning of trial, the license revocation.
An opening statement and closing argument.
Correct, Your Honor.
Right, but there's some sort of test, like Durrani's cross-examined in a deposition in front of the jury on this, right?
Correct, Your Honor.
Okay.
But our point is, any reference to the license revocation would have been an error. It should have been excluded per this court's decision in Setters 1.
Well, we didn't say that it blanketly should be excluded. We just said that the way it came in Setters, because it wasn't tied to any kind of dishonesty, is a problem.
A problem that is not solved here in Potts.
We don't know because we don't know how he was cross-examined because of which deposition was played. My understanding from the collage is they're trying to tie the license revocation to dishonesty in some way. And I'm curious if they were able to do that here, because we're not sure what deposition was played.
But one thing to point out, Your Honors, first of all, it does not appear from the references to medical license revocation in this trial transcript that it was, in fact, an effort to tie Dr. Durrani to dishonesty the way that a lot of the collage evidence is. It was to tell the jury this physician doesn't have a license. And you'll notice it's not defended in either the motion practice below or in the briefs here as attempting to tie Dr. Durrani to dishonesty. It is just, yeah, he's a physician who lost his medical license.
Even if we assume that there's a problem with the admission of the license revocations, why is that error not harmless in this case like it was in Setters 1?
Your Honor, I think I would again, you look at the size of particularly the punitive damage award. The jury was clearly mad about something. And you have a serious collection of evidentiaries. I understand Your Honor's point about the perforated colon does seem to be a serious problem, though that gets resolved. The perforated colon is resolved, and Mr. Potts basically returns to normal digestive function. The sepsis gets cleared up. Oddly enough, those injuries end up not being permanent. What ends up lasting for Mr. Potts is largely the pain and suffering he was experiencing for decades prior to ever going to see Dr. Durrani. And on the subject of the perforated colon and the sepsis, this is one area where Dr. Ciani's testimony in this case is problematic in a way that is beyond what you permitted in Adams. So in Adams, you said he's a radiologist, he's allowed to opine on reading radiology reports and making surgical recommendations after that. He is not qualified to tell the jury, by the way, this surgery was actually performed negligently.
Can you give us specifics on that one, where he went, I guess, astray or out of his lane?
Sure, Honor. Unfortunately, I'll have to flip to it. We do cite that point give you a record cite for that in our briefing.
Mm-hmm.
Where he
So
suggests.
just a couple times, right? Like he doesn't get it really into detail about the surgery, but he does opine a little bit on
Things like the position of the plaintiff
Right.
During surgery is what caused the perforated colon, which suggests that the surgical
And were there
technique was off.
contemporaneous objections to those questions in particular?
That one I do not have offhand, Your Honor, though point out we did object to Dr. Ciani being able to opine on these issues generally.
at all.
At all.
Right.
And then sort of had to live with the fact that he was allowed to opine, at least consistent with Adams, and then he decides to go well beyond Adams. Your Honor, I have to express.
Did any other expert testify that these issues were a problem with the surgery, like being on a certain side, or was this duplicative of any other expert's testimony?
Not that I recall off the top of my head, Your Honor. Your Honor, I have to express a little concern. I've heard the phrase, but this was only mentioned once or twice or only a couple of times over the course of trial. Your Honor, I'm not sure how many times an expert has to offer an opinion that a surgery was performed negligently that is beyond his competence to testify before that testimony ought to be excluded. I'm not sure how many times saying the defendant gave Mr. Potts breast cancer sort of crosses the threshold from accidental or ordinary mistaken into prejudicial. If I were to tell you, by the way, my colleague Mr. Winter is a felon, saying it 4 times or saying it once or standing up here and spending the balance of my time, whatever may be left, repeating it doesn't make a difference. The problem is to say it. The problem is to tell the jury, after stipulating that it would be excluded.
No, and we understand that, and I think what we're wrestling with is if you have an error that is repeated multiple times, then it is something that looks less and less like harmless error. But if there is an error that happens once or sporadically, we have to weigh that in the harmless error calculation. We understand that.
This one is fairly significant. One last point, Judge Krause, you mentioned the jury interrogatories. The jury interrogatories are not specific about what the jury thinks negligence is. They just think there was sort of an error in the performance of the surgery that caused Mr. Potts injuries. The jury doesn't specify, we think he's receiving compensatory damages because of the perforated colon or because of the collapsed lung or because of the cancer.
Or that the surgery wasn't indicated in the first place.
Right. So you have the jury saying we find negligence here that caused an injury, and an expert saying that among the injuries caused by the surgery is the breast cancer. And so you end up with this sort of grossly outsized award.
You are beyond your time. I'll still reserve it. We've been peppering you with questions, so you can still have your 3-minute rebuttal.
Thank you, Your Honor.
Thank you. Mr. Winter? There was no cross appeal on this case, so you have a full 15 minutes here.
I guess we'll deal with the cancer first. This is a whole lot like that situation we had in Stevenson, where Mr. Stevenson, my client, went out and talked to the jury, and we had the judge intervene and do as brief of an investigation as you can under the circumstances. Then he basically gives you a Yogi Bear a minute, When you're at the fork in the road, take it. Either you ask for a deal with the jury and all those things, or you ask for a mistrial. And at least in Stevenson, we know what happened. Here they kept on going.
They asked for a mistrial.
I'm sorry.
They asked for a mistrial here, right?
That's my recollection. It's running
Yeah.
together, but I don't know if defense counsel would ask for a mistrial. It might have been granted. I don't know, but
Here?
No.
Oh, okay. You're talking about Stevenson.
Yeah, I'm in Stevenson, but I don't believe a mistrial was asked for here. And as far as I know, I looked at my colleague's closing. BMP2 wasn't mentioned at all by him.
Yeah, there was a court order saying don't mention it.
Well, heck yeah,
Well, they did move for a mistrial here.
they did.
Yes.
Oh, okay.
Okay.
They were-
That's what their argument is. A mistrial should have been granted because of this reference, that it was so prejudicial.
I don't think that the judge abused discretion in plowing on.
Why not?
Because nothing happened afterward, other than the jury rendering a jury verdict. But there are so many other moving parts to a jury verdict that I think BMP2 was just not mentioned anymore. It wasn't.
Is that the only time it was mentioned?
I'm sorry?
Is that the only time it was
That's
mentioned?
my recollection, yeah. I can't remember any other time when I read the transcript that it happened. And I'm looking at, that we can all look at the jury interrogatories. BMP2 was nowhere to be found. I would think that if they were offended by BMP2, that would have been mentioned, but it wasn't.
Do you know which Durrani depot was played for the jury in this case?
I do not.
Okay.
I do not, no. With regard to, we hear a lot about Durrani, Pakistani, racial prejudice, and I just don't see that. He's asked, where were you born, where were you? The basic things that if I got on a stand and somebody started examining me, I'm from Pittsburgh. There's a lot of prejudice about that, I'm sure. But the fact finder would get to the meat, whoever my testimony is going to be in.
Yeah, but, look, it's hard to tell reading the record, but
Yeah.
as I read the record, it does seem like the comments are designed to kind of gin up some
Gin up.
animosity, because it's like, I mean, it's essentially, he's a foreigner. He got, his medical license from, or went to medical school in Pakistan. He's fled to Pakistan. Send a message, make sure he can hear it in Pakistan. Like, at some level, you're right, it's just background, but at another level, it starts to look more problematic.
But take a look at all of the things that he did, the exaggerations, the false readings of MRIs and other imaging.
Why is evidence being introduced that his family owns a textile business in Pakistan? What's the evidentiary value of that?
I don't have an answer for that. I'm sorry.
What about him losing privileges at a hospital for not, I forget what he didn't do something timely, and he lost some hospital privileges? What is that
I
purpose
know
of
in
that?
some cases, he performed surgery when he didn't have privileges.
Okay.
I don't believe this is one of those, but I know for a fact that happened.
Okay. But if it was introduced for a case where he hadn't lost his privileges, would it be relevant?
If objected to, I'd have to think about it, but
Okay.
yeah, that's a good issue.
And the license revocation,
I think we've been down
was that relevant here?
I think we have that problem throughout, and
So your argument is that it shouldn't have come in, but it was harmless? Is that,
yes,
okay, and how is the license revocation harmless in this case?
because this court has said so in the past.
Well, you have to analyze it on a case-by-case basis.
Right.
So how is it harmless in this particular case?
Because as this court said in Adams, it was the culpability is overwhelming. It's just overwhelming what this doctor did to my client. By decedent, I should say more accurately. I think from my brief at 3 through 13 sets forth what Durrani did or what Durrani interpreted and what Doctors Wilkie, Bloomfield, and Ciani say with regard to his misinterpretation of imaging, his methods of surgery.
Were
No matter-
there any experts besides Dr. Sayani who testified that these surgical methods were not normal? Did anyone besides the radiologist speak to turning him on his side and using these different methods that led to the colon tear?
Doctors Bloomfield and Wilkie testified about his lack of surgical prowess procedure.
What about specifically about the methods that Ciani testified about, which they're saying is beyond the scope of what he can testify about? Did the other two experts also say the same thing that Ciani?
I know Bloomfield talked a lot about the radiology.
Well, not about the radiology, about the surgery and the methods that were used. Like putting him on his side, that's the big one.
Well, I think that
Unorthodox.
my two doctors, the orthopedic surgeon and the neurosurgeon testified that the methods used by Dr. Diani didn't meet the standard of care. Whatever Ciani said or might have said that was improper, and I'm not conceding that, is cumulative.
You think that the radiologist could testify about a non-standard technique of placing Mr. Potts with his right side up during surgery?
If it dealt with radiology,
But he's talking about the surgery technique. Is that proper?
No,
For
but
him to
it
test?
it ought to be objected to.
Okay, but it's not proper for him to go and testify about surgery technique, right?
I mean, if I were defense counsel, I probably would object to that, to the question.
Okay,
I don't think it was.
okay,
I was reading my brief while this was going on, while this topic was being discussed, and I looked and saw a statement that none of none of Dr. Ciani's testimony was objected to. Unfortunately, I didn't bother to put down the citations. And
okay.
what I meant was on the specific questions, yes.
So you're saying that even if he testified improperly about the surgery, it was, that this is waived because they didn't object?
And it's cumulative,
Because other experts testified about this?
yes.
Okay,
And one other thing, there was this echo chamber argument, if I may use those words, that if you say it often enough, it'll be believed. Well, I mean, defense had two doctors there, too, Dr. Marks, and I forgot the other doctor's name, my problem, not theirs, but they had a lot to say, and they had the misfortune of not of the verdict going against what their testimony would lead them to believe. I mean, it wasn't just unilateral pinging of the jury of, bad doctor Durrani. He had some help, just it wasn't good enough, or wasn't enough. I guess I'm close to run-up time. I've set off, there were intentional torts here. Adams would apply, and the judge made an error by agreeing to set off, I think it was $3,600 and some change.
well, you didn't do a cross appeal in this case, right? I don't think so.
I think you did.
Yeah, 220034.
Did you raise, I mean, I could be mistaken, but I thought you didn't raise any arguments on it.
If I didn't raise, there was one.
I mean, I know you filed a cross
I ran out
appeal,
of pages.
but
Yeah,
you did not
I-
raise any cross assignments of error in your brief.
I waived it, sorry.
Okay, just checking.
Yeah, I just ran out of pages in brief, so I
Okay.
skipped.
So there's no issue as far as
No.
the cross appeal on the set off?
Correct,
Okay,
correct, yeah. Thank you, judges.
thank you. Yes.
Your Honors, if I may start with a little cleanup on Dr. Ciani. So we did object to Dr. Ciani, specifically to him being able to testify on surgical performance before he took the stand. So you'll find that in the footnote on page 16 of our brief. It's in pages 1113 through 1115 of the trial transcript. It's been our consistent position that Dr. Ciani is not competent to testify about surgical performance, and in this case, our objection is overruled, and then he goes off and testifies in the fashion that you heard here. And the places where where he's testifying on the technique and the performance of the surgery, it's pages 1173 to 1189, which will be in volume 12 of the trial transcript if you're hunting.
What about other experts? Did any other expert testify about the non-standard techniques and similar items?
I have nothing to offer you on that
Okay.
score. Point out my colleague who bore the burden of proof at trial does not either.
Right.
On the subject of sort of how do we see that these evidentiary errors, of which there were no small number, are actually prejudicial. We rarely get to see why the jury enters the award that it enters. I don't think ever in the history of Ohio jurisprudence have you had a case go up on appeal where a jury verdict form said, we rendered this decision because we were really angry with the defendant. You will never see a jury verdict form that says, by the time I got to the end of the 2 weeks worth of trial, I thought this was a terrible character who ought to be punished. Except when you see punitive damage awards. And so to say, look, the cancer diagnosis didn't show up in the jury interrogatory, Dr. Ciani's testimony is not referenced in the jury interrogatory, doesn't tell us anything, because Dr. Bloomfield's testimony isn't referenced there either. Dr. Wilkie's testimony isn't referenced there either. What we're looking at is, well, what were the errors that were committed at trial? How bad were they? And again, telling the jury that a man got breast cancer is a pretty significant error. Having a radiologist testify outside of his competence to say, because you tried some new and untested surgical technique, you caused this man serious injuries. Judge Bergeron, to go to your point about the nature of the injuries in this case, you have an expert not competent to testify telling the jury the reason that this plaintiff was injured is because the defendant did not perform the surgery well. So even as to the nature of the injuries in this case, you have an evidentiary error doing a fair amount of the causation and damages work. And so when you take that, the sum total of those errors, and then you look at the size of the verdict that the jury returned in this case, can we really say radiologists providing causation testimony outside of competence, the cancer diagnosis, the medical license revocations, all those taken together had nothing to do with the outcome of this case for an individual that I have to repeat was on permanent disability for 15 years and was an opioid addict before he ever went to see Dr. Durrani. And from that, we are supposed to believe that Dr. Durrani did $13 million worth of damage to him, earned a $26 million punitive damage award, and none of that had anything to do with the evidentiary errors in this case. Your Honor, if those errors are harmless, I'm not sure I'm going to be able to come back in front of you whenever when one of these cases is on appeal.
Thank
Your
you.
Honors, give me a second, I will switch over and we'll go to the next round.
So this case is submitted, and we will take about a 3 to 5 minute break, let you get switched around, and we're going to go off the bench for a minute, okay?
Thank you.
Thank you.
All rise. The Court of Appeals, First Appellate District of Ohio is now in recess. The cameras are still on. I paused the video, the audio.
Try to be there as fast as we can, but we're one more. Different personnel. Budget, people not want to do the guys anymore.
Yes.
And obviously, he's doing that in sport, right? So.
So you on the front end or tail end?
Yes or no?
It's on the tail end of the partnership, so I'll
Okay.
finish it here at the end of August, and I'll be starting the mornings.
Good job.
Yeah, cool.
Yeah, all right. Can't say much rules.
All rise. Court of Appeals, First Appellate District of Ohio is back in session. Please be seated.
Okay. The next case up is McCann versus Durrani. There is a cross appeal on this one. Mr. Williamson, 3 minutes for rebuttal,
Correct, Your Honor.
and Mr. Winter, 2 minutes. Okay.
May it please the court, I again come to you with something new. A relatively limited set of evidentiary errors in this case, and it's mostly going to be questions of law. And I think the easiest case for you to send back to a judgment of $0. And that's the case of Ms. McCann. The numbers matter a little bit here. You have a jury verdict of about $208,000, a set-off of about $157,000, and the result was a $50,000 judgment, $50,445.57.
So by your logic from the last case, then there's no real errors here because there's such a small verdict. Sorry, I couldn't resist.
Well, no, Your Honor, so we do think that there were a number of evidentiary errors in this case, but we decided not to bring most of them to you for exactly that reason. Instead, we want to focus on a couple of core damages problems. First is standing to seek past medical damages, something I think we covered a lot of this ground yesterday. If you don't have questions, I won't bore you with more of it this afternoon.
I do have one, just to clarify. It looked like from the briefing that Medicare paid all of Ms. McCann's bills. Is that accurate?
Correct, Your Honor.
All right, she had no out-of-pocket?
Correct, Your
In
Honor.
this case? Okay, thank you.
And Medicare was identified as the real party in interest. This was prior to trial?
Correct, Your Honor. I think the most important motion comes in a directed verdict motion at trial. But this is a case where there was sort of no dispute over the course of litigation that the real party in interest here is Medicare.
But your argument with all of these is that the standing issue should have been decided before anything went to the jury.
Correct, Your Honor. And in this case, you have the trial court actually telling us, I will take up this issue after trial.
Okay.
And then he doesn't.
Would that have been appropriate to take it up after the trial?
Well, Your Honor, we think he should have granted the motion because the facts were not in dispute at the time. And it didn't get better post-trial, which is why we filed a post-trial motion on the same issue. The court again said, I'll give Ms. McCann some more time to sort out her standing issues. And then 21 months pass with no resolution. And then unlike in some of the other cases where you do eventually have a plaintiff come back and say, we've got the lien sorted out, you never really get a resolution to the Medicare problem in this case.
But are you saying, so you're not necessarily arguing that prior to presenting this evidence to the jury, standing had to be sorted out already?
Well, I think we're sort of entitled to challenge standing at really any place that appears, and we do have it. Before this case goes to the jury, we have made clear we have a standing problem here. We have a standing problem here. Ms. McCann knew that she had a standing problem here. Your Honor, and I recognize that you were not impressed with defenses raised in the answer, but the answer and the complaint in a case serve the same purpose, which is to put the other side on notice of issues, liabilities, problems that they are facing.
Is that all we have here, pre-trial, is the answer, or was there additional filings?
Your Honor, I don't have additional filings. I owing to, I think, some of the record issues that you all have identified. Kind of the arc of this collection of cases, and it's not unlike the Schreikert hearing I think that Judge Kinsley was talking about with respect to the Durrani collage, is you have, in this case, basically 8 or 10 cases that start off on parallel litigation tracks. You have some joint hearings with the court setting a trial schedule. You have some consolidated hearings with the court addressing motions limine and setting some pretrial orders. And in those hearings, these real party and interest questions get raised. In sort of the course of the Durrani hearing, by the time we get to this trial in 2019, everyone recognizes that real party and interest is an issue, that it is a problem that plaintiffs need to resolve, and you see plaintiffs starting to attempt to deal with it. So you saw some of that in Hounshell and in Eagle yesterday, where you have pretrial filings from plaintiffs, indicating we know standing's not established, real party interest is a problem, we're trying to join the insurers, let's proceed to trial anyway. So what you, long way of saying, Your Honor, what you do not have here is a situation where the parties are unaware or where this issue is not being pursued, just unfortunately, maybe not necessarily under this case caption.
Right, but I guess at that point, when everybody agrees that Medicare is the real party in interest that should be joined prior to trial, should the plaintiff have even been able to present any evidence on the medical bills at that stage, if the Medicare is not joined?
Your Honor, we think no.
Yeah.
I am willing to live with a contrary ruling in this case because the outcome doesn't change, which is she didn't have standing, so she's not entitled to the award.
She's not entitled. So it's not about just presenting the evidence to the jury. It's the fact now she shouldn't get the award.
Right. Your Honor, we have some cases where we think the issue is sort of fully fleshed out, fully litigated before trial. I think in particular in Eagle, we go to trial over objection on the past medical damages issue. I'm willing to accept, sure, she gets to bring it to the jury in this case, but it's not an award that she's entitled to because she does not have standing. And, Your Honor, I have to point out, it's the plaintiff's job to have and to establish standing. And so our argument in this case, and I cannot emphasize enough, in this case, what is clear is that she did not have standing before this case goes to the jury. She did not have standing when post-trial motions were filed. She did not establish standing at any point during the 21 months after trial, despite some repeated prompting from both the court and from defendants' counsel saying, look, this issue is still ongoing. It's still hanging out here. We have pending motions on this question, including the court telling us in the directed verdict motion, I'll take it up after trial, and it's still not resolved.
Counsel, I understand that this is an iterative process, both from the parties' perspective and the courts as well. I want to ask you some questions about this prejudgment, or real party and interest issue, divorced from this factual record.
Sure.
So would it be the case that the defense would know from the outset of being sued who had actually paid its bills?
Would the defense know? Not in every case, no.
All right. So there may need to be some discovery beyond the answer for the defense to understand who would be the real party in interest?
Yes, Your Honor.
Okay.
The complaint does not normally allege, and all of my medical bills were paid by, Humana or Aetna or what have you.
All right. So it may be the case that Dr. Durrani, let's say, or CAST, received all of its payments from Medicare, and it would know that. But it may also be the case that the plaintiff paid the bills and then got reimbursed from an insurance company, and you wouldn't know that.
Correct, Your Honor.
And you'd need discovery for that.
Exactly, Your Honor. And I would also point, in some of these cases, you have allegations that there are, besides sort of going to see Durrani, there are other, alleged complications caused by surgery, plaintiffs seeking treatment in other places where Durrani is not the one receiving the bill. would have no idea whether a plaintiff's paying those out of pocket or, Medicare is paying.
All
or even
right.
what those bills are.
All right, and so while you might be able to generally raise the issue and the answer, in some of the time you'd need discovery, and then you could raise this again in some kind of pretrial motion.
Assuming that we're sort of in possession or receipt of all of the bills in advance of trial, yes.
Would you ever be ambushed at trial with any new information in this context?
Oh, absolutely, Your Honor.
All right, so it's possible that something new could come out at trial about bills from an insurer that you didn't know about.
Correct, Your Honor. You may have something as simple as, being able to ask a plaintiff for the first time at trial, tell me about your past medical damages, what doctors have you gone to see, who paid those bills, that sort of thing. And so you may not find out until the close of the plaintiff's case in chief that in fact, there are no out-of-pocket costs.
All right, that's very helpful. Thank you.
Your Honor, one of the pieces of good news here is when you look at the amount of the jury verdict that's left after set-off, if you zero out the past medical damages, you have a judgment of 0. You can reverse and remand with instructions to enter a judgment in favor of Dr. Durrani and Cast. Future medical damages, unfortunately, don't quite get you there. If you zero out the future medical damages, you're still left with a verdict of $545.57. Future medical damages, in this case, end up being utterly speculative. So you have 2 experts testifying on plaintiff's behalf on future medical damages, Drs. Bloomfield and Wilkie. Dr. Bloomfield.
Wait, are we talking about $500 here?
So future medical damages were about $50,000.
Oh, okay.
But if you zero those out, the judgment that you're left with is $545.
All right. Can I?
I would not be here on a $500 case, Your Honor.
Can I redirect you to the prejudgment interest for a moment?
Absolutely.
And I realize that and this is more of a global question, I realize that there was a demand of like $7 million, which you all perceived as arbitrarily high, and then on the morning of trial, there was an offer for $1 million. I guess the thing that I'm struggling with on prejudgment interest is it seems like, at least as I'm getting from the briefs, and I haven't like peeled back the layers of the onion from the record, but that you all did not respond to the settlement demands being made by plaintiff's counsel. And am I wrong about that? And if I'm not wrong about that, is a defendant simply not responding sufficient to insulate themselves under the prejudgment interest statute? Because what I'm concerned about is if we were to say like, oh yeah, a defendant doesn't need to do anything, they can just sit there, are we really encouraging the good faith settlement dialogue that I think is the purpose of the statute? That was long-winded, I apologize. But
I think a few layers of the onion to peel back there. First, Your Honor, and this is maybe the most important sort of baseline piece, is that plaintiff bears the burden of proving the entitlement to prejudgment interest, and they have to check at least 2 boxes. One of those boxes, and I hate that the statute sets all of these up as double negatives, but basically, the plaintiff has to make a good faith effort to settle, and the defendant has to fail to make a good faith effort to settle. There are a few ways that you can evaluate whether the plaintiff has made a good faith effort, including, did they make a demand? Did they make a demand that was reasonable given the facts of the case? Did they make a demand that was reasonable in terms of its timing? On the defendant's side of the ledger, you look, one of the questions is, did the defendant, say a non-responsive defendant, and generally speaking, Dr. Durrani did not respond to these $1 million day of trial demands. That much we'll concede. There have been a number of court-supervised mediations. It hasn't been sort of complete radio silence from our side, but as to these sort of stock $1 million demands, generally speaking, no response. A plaintiff or a defendant does not have to make a settlement offer if he has a good faith belief that there's going to be no or low liability in the case. And in this case, you have a $1 million demand made the morning of trial, which seems fairly late in the game, on a case that on the morning of trial could not have been worth more than about $760,000. And all of the information about the value of the case was in the possession of the plaintiff the morning of trial when they made that demand. They knew the past meds, they knew the statutory damage caps, they knew their standing issues on past medical damages, and they knew what sort of the ceiling, the potential ceiling on non-economic damages would be. There's no way that the plaintiff could have recovered more than about $750,000 in this case and still demanded on the morning of trial.
Right, yeah, the morning of trial is problematic here, but I guess.
It's not a good faith effort to settle.
Okay, fair point. So let me give you a hypothetical, and let's assume that a month prior to trial, they made a demand of $250,000, and you all just didn't respond to it. You get the email and you just click delete. And what I'm trying to understand is.
It might be illegal malpractice. Go on.
Well, right. But what I'm trying to understand is there an obligation on the defendant, even if the defendant believes that they have no liability, or there's at least a good faith basis for believing there's no liability, can the defendant just ignore settlement demands from plaintiffs and still be protected from under the statute?
So
or do they have to do something? Do they have to send a nice letter and say, well, I appreciate this, but here's all the reasons we disagree with it? And I don't know if that matters.
So the statute doesn't require that. And the statute does not require a settlement offer if the plaintiff has a defendant has a good faith belief that they're not going to have any liability at trial. And so there are actually some scenarios in which you could have offered made a $250,000 settlement demand in a $500,000 case. The defendant does not respond, and there's still no entitlement to prejudgment interest. If the defendant if there's some evidence that the court can look at to say, yeah, the defendant rationally calculated his sort of odds of trial, the range of potential outcomes, and said, we think we have a pretty good shot at winning this one. We'd rather try it than write the check. A defendant is allowed to make that call. Now, there are instances where, in fact, the defendant wouldn't be protected if, for example, the email comes and I simply hit delete because I don't want to read anything that Mr. Winter sends me. You might have a defendant on a different posture there if there's no evidence that there was some sort of rational thinking about what is this case worth and what are our chances of losing.
To Judge Bergeron's questions, is the lack of good faith bad faith, or is the lack of good faith just nothing? I mean, is there something in between those two?
Your Honor, I wish that there were an easy answer to that question, but unfortunately that is one that lies with this court and the Supreme Court, which has basically said both. So there is some case law that suggests it's two sides of a singular coin, right? You're either acting in good faith or you're acting in bad faith. And then you have the kind of double negative framing of the statute itself. It's the plaintiff shall not fail to have made a good faith effort to settle, where it's, well, maybe you have good faith, neutral, and bad faith, and what you're looking for is good faith somewhere. It's a long way of saying, I don't know the answer, but that's been a matter of sort of judicial parsing that's been all over the map.
I mean, would we have to imply that nonchalance in the face of a settlement offer is bad faith in order to subvert this statute?
If you're asking me, to apply the straightforward language of the statutes, I think you're just looking for good faith on both sides. So you need a good faith offer or a good faith effort to settle from the plaintiff, and you need a good faith effort to settle from the defendant. Important to remember, failure of either one of those points is fatal to a claim for prejudgment interest. Regardless of the bad faith of the defendant, if the plaintiff does not make a good faith effort to settle, the plaintiff does not get prejudgment interest.
So here there was no effort to settle by the defense.
Right, Your Honor.
But you're saying that no effort was in good faith.
Right, Your Honor, because one of the things you're allowed to do is say, I think I have a reasonable chance of non-liability here. The point is to encourage settlement of cases where it seems reasonably likely that that a defendant is going to be found liable. You want to sort of bring defendants to the table to settle, so you can get these cases off your trial calendar. It's not meant to basically bully defendants who think they have a strong case into settling anyway so that they avoid prejudgment interest. And one of the ways that you do that is that you require a plaintiff to start the good faith dialogue. And I think in this case, it's really hard to say that a good faith dialogue started with a demand the morning of trial for 33% more than the case could possibly have been worth. And this is not me sort of trying to be backwards looking and saying it's $1 million demand on what was ultimately a $200,000 verdict, because I don't think that's what the statute requires. It was $1 million demand on a case that on its best day is $750,000. And that's just not a good faith effort to settle, and that failure is fatal on prejudgment interest. Alongside, and I think we cover the water in this in our briefs, the fact that the motion for prejudgment interest was withdrawn and never reinstated. The trial court granted a motion that was not pending in front of it.
You are at your time, beyond your
Yeah.
time, but I will reserve your rebuttal.
Thank you, Your Honor.
Thank you. Mr. Winter.
I'll do my best to cover the matters.
Can you
seriatim.
just get into withdrawing the prejudgment interest motion? I know we asked you about this yesterday.
Sure, we just needed to get a final, try to create a final appealable order at the trial court. There were two pending motions. The way we thought to make that happen would be to withdraw the motions.
Right, but the plaintiff didn't even want prejudgment interest then, right? The trial court just kind of brought it back.
In Pearson, I mispronounced it, this court followed that case, said that our motion, our notice of withdrawal is a nullity, and I dug up into Black's Law Dictionary 4th edition to say that it never existed, and then this court ordered the matter reinstated and decided.
But as we're understanding your perspective from our discussion yesterday, your clients and you engaged in a calculation of money versus time, and you chose time. You wanted to get the show on the road.
Correct.
And you were willing to forego some money in order to do that, which we understand, because the more that time passes, the money is not coming in the door, and you need the time to go by and finish the process so you can eventually get to the money. We understand. So it sounds like the withdrawal of the prejudgment interest motion was a calculated decision weighing money versus time, rather than relying upon a decision of this court that labeled that a nullity based on some procedural concerns.
All that's true.
All right, thank you. Thank you for clarifying that.
Sure. The notice was a nullity. This court sent the matter back for a decision. I mean, that's law of the case. We're done with it. We have a decision. It could have been zero. It could have been what it was, could have been something else. But it's decided, and now we're here.
Can you help us understand, outside of the cases we've heard yesterday and today, how many more, if any, cases to come have prejudgment interest motions in them that have been withdrawn? Is this an issue likely to recur?
The cans later on today, Mittendorf, 2 or 3 others.
Okay,
I mean, it's not a big.
A small number?
It's a small number.
all right, thank you.
Yeah. Okay. While we're on prejudgment interest, the appellant's insurance company has said, we will not settle any Dr. Durrani case. And we've put that in our motions. They just won't.
Was that, because I recall, and I don't know which case it was, that in your pleadings in this, for the prejudgment interest had some emails attached. Were there emails to that effect, that they're just like, we're not going to settle any case, doesn't matter? I mean, is that in the record?
Not in this, before this court. It may be in a federal court somewhere.
So what you just said, that they said, we will not settle any Durrani case, is not in this record?
Other than the pleading where we stated what Medical Protective said in its adjuster, and they will not settle.
So we
They
have,
just
we have something in this record that says we will not settle any Durrani case?
Motion for prejudgment
Or is this
interest,
case?
document 228, page 3. Emphasis added.
And what is that? What does that say?
That's where we have a motion for prejudgment interest.
Okay.
But is that citing to like an affidavit, or was there, like, what's the underlying source of that? Was there, to Judge Cuss' point, is there an email, is there an affidavit that says?
It was, I know what the fact is, I don't know if the document says what I'm about to say, but it was an authorized representative of Medical Protective stating to one of our attorneys, we will not make any settlement on the Durrani case, period.
Because that's different than what they're arguing, is that they calculated this case, and that their refusal to settle was based upon their evaluation of this particular case.
Well, assuming that's true, they have these algorithms at Medical Protective and whatever, but if you look at pages 21 to 22 of the brief, they kind of forget all the favorable Durrani victim judgments that have been rendered once all these cases were taken out of Butler County. I can't imagine an underwriter or an adjuster taking a look at any of these cases, and they're saying there's a range of judgments between 50 and 75 or something like that, with a certain probability of victory or loss, and Durrani is a lousy witness because he doesn't cooperate. I mean, that cries out for some sort of settlement.
But initially, it sounds like the initial settlement offer was over $7 million.
Yeah.
And the judge is like, that was kind of ridiculous.
I agree.
And defense didn't even have to respond to that.
I agree.
So then they throw out $1 million, which is the same settlement offer that apparently they've been throwing out in every case on the day of or eve of trial, right?
Yeah, or before, $1 million, because that's pretty close to what happens on
But doesn't the $1 million
Victims.
have to be calculated in relation to this particular case and the circumstances of this case? I mean, doesn't the judge have to kind of examine? He seemed to only look at the fact that they didn't make a settlement offer in response, but doesn't he also have to look at the plaintiff's offer to determine if that's a good faith offer? And if the plaintiff is simply throwing out $1 million in every trial right on the eve of trial, how is that good faith?
I have some empirical evidence on page 21 and 22 of the brief where we set forth the actual.
Right, but I think the issue is not what is the average in other cases, but what is the potential damage exposure in this particular case. In this case, looks like it's an outlier on the low side in terms of potential damages, and so why would a rational defendant kind of treat this on par with other cases that might be more egregious on the
Why not they
damages.
call me up, or my colleague, and say, hey, Bob, you're a little on the high side here. How about 500,000? I mean,
So you're saying they have to respond, they have to give some kind of response is what you're saying?
Yeah,
Well, they didn't have to do the 7 million,
Correct. I
because
mean,
that was
sure,
outrageous.
I agree with that.
But you're saying the million is not outrageous, so they had to make a response to that.
They should have,
And
yes.
the statute focuses, though, on both their good faith and your good faith. What about this argument that the $1 million exceeded by a good clip? What was ever recoverable at trial in this case?
Well,
How
that's
is that
what-
good faith?
That's what they're saying.
Do you dispute that?
I haven't given it any thought, Judge. But, I mean, I wasn't there to put the pen on the paper. I just know what our practice is. You know, $1 million, let's have some dialogue. And it's always, always silence, crickets. We have yet to receive any settlement offer in an individual Durrani case. So, you know, why go through the exercise? We know what the answer will be, crickets. I mean, equity doesn't require
it's
the
just-
doing of
it's
a
just-
needless act.
It's just kind of the presumption, based on past experience, that there's no point in really getting into settlement negotiations because they're going to always say no.
They don't even give us favor us with the offer of no. It's crickets.
Okay.
Nothing.
Silence.
And that,
Can you, before your time is up, can you walk me through the math on the set-off issue? So in this case, unlike the others that we've seen, there was a 50-50 apportionment on non-economic damages. But the trial court, I think, granted a set-off for the entire $157,000 settlement.
that was the apportionment granted by the administrator of the Westchester Settlement Fund to this case.
Okay, so the set-off was also apportioned.
Yes.
All right, thank you.
Yeah, okay. But while we're here, that, you know, the jury came back with a negligence and an intentional tort. Adams kicks in, there's no entitlement to a set-off. And of course, we also have the backup argument of they have to be joint tortfeasors, and they're not joint tortfeasors. And if I can have just a second on this settlement of the Medicare. The Medicare, as I recall in the brief, that was settled in August of 20-ish, you know, after trial. And Medicare took their money, and under Robinson, we get the balance.
How do we know that Medicare took their money? Do we have anything in the record on that?
Yes, I mean, I don't have a receipt for cash or a check, nothing like that, but
Wait, who, Medicare took the money from whom?
my people, or the settlement fund.
So was there was a
I'm
a
trying to
lien or something?
Yeah, there was a.
And
yeah,
they
there was
settled
a
the lien?
There was a lien.
Oh, you mean on the settlement proceeds from the hospital?
Right, this wasn't,
Okay,
I'm sorry,
understood.
I'm jumping around
Understood.
before the meter runs out. And I wanted to follow up with a loose end from yesterday. Medicare does not have has the discretion not to show up when we invite them to our lawsuit, and I refer you to Johnson versus Stachel, 2020, Ohio 3015, paragraph 64. So we can ask them all they want, and they don't have to show up.
So they didn't show up. The trial court then, I guess, made some sort of finding that Medicare had settled its medical lien with
Yeah.
McCann. Is that right?
Right, and I'm trying to see if the defense was involved in the notice on this thing. I have it in my brief. Here we go, page 11. They dismissed voluntarily, TD 280. It dismissed all its claims, TD 281. Then the trial court summarized it, its decision at TD 298, page 7. Here it. The judge said, defendants acknowledge that Medicare has settled its lien with plaintiffs on all claims in a number of Durrani cases, including this one. Accordingly, the court finds that the entire amount of $58K and change that the jury awarded to plaintiff for past medical bills shall be retained by plaintiff. That's at page 11 of my brief, and it cites to the record.
Okay. Thank you.
I think that's all I can do for now. Thank you.
Okay, thank you. Mr. Williams.
So, Mr. Williamson, if Medicare was paid out of a settlement received from another defendant, does that obviate this issue on standing here?
No. Because again, regardless of where sort of Medicare got their money, so the first problem is none of that is documented, given to the defendants. We have no opportunity to see that, test it, ask any questions about it.
I thought the defendants acknowledged, I thought the judge's order said the defendants acknowledged that the claims were settled.
We acknowledge the claims are settled. We don't get a chance to see, test, find out from where those claims settled. But more important, there are, I think, two important issues here to go to Judge Bergeron's question. The first is we didn't solve the standing problem at trial when it was raised. Wasn't solved in the post-trial motions. After the trial court denied the directed verdict motion on the ground that I will deal with this after trial, and then didn't, and gave Ms. McCann almost 2 years to sort out standing that apparently comes out of we're hearing today, a settlement with other defendants. The core problem is Ms. McCann doesn't have standing. She didn't have standing, never established standing to receive these damages, and so the idea that she gets to keep the balance here.
She didn't have standing until, potentially, Medicare settled its claim with her and essentially assigned its claim to her, right? And at that point, she arguably had standing.
That is assuming that there was an assignment of the claim to her. It's itself, I think, a dubious proposition, at least not established in this record.
And in this case, as best we know, because the record doesn't have any of these filings, but as best we know, that occurred post-trial?
Significantly post-trial, Your Honor, yes.
All right, thank you.
And, Your Honor, I would be remiss if I didn't express some frustration at the idea that having moved for a directed verdict and been told, I'll take this up post-trial, taking it up post-trial meant, well, let's give her 2 years to sort it out to moot your motion. That's a tough pill to ask defendants to swallow here.
Well, that's why I asked if this all should have been sorted pre-trial before anything went to the jury. It just seems...
Would have been nice, Your Honor. No disagreement with you there.
I mean, as a result of all this, the jury didn't know that it was resolving Medicare's rights in this case, did it?
Well, I think they would have been on notice of it around the time we made the directed verdict motion, and we now sort of have all of the evidence on who's paying the bills. But at that point, particularly with the court having denied the directed verdict motion, it wasn't as though we could go to the jury and say, return a zero verdict on past medical damages because actually someone else is responsible. The court's DV motion or DV decision here basically ensured that the question of past medical damages was going to go to the jury.
You are at your time.
Then if you don't have any questions on The remaining issues, we will stand, particularly on our reply brief on prejudgment interest. Thank you, Your Honors.
Thank you. Thank you both. The McCann case is now submitted. And the next case up is the Stratman case. Good morning, Mr. Hoodfoot. Would you like 3 minutes for rebuttal?
I would, Your Honor. Thank you.
And Mr. Winter, this is a cross appeal.
Yes, Your Honor.
2 minutes? Okay.
Yes, Your Honor. Good morning, Your Honors. Aaron Herzig for appellants. May it please the court. The new ground here is the absence instruction, I think, and I'd like to spend most of my time on that. I would just note, in terms of your harmlessness review in the event that you find the other areas that we've talked about today, this was a surgery that happens after years of conservative treatment where several other physicians have seen the same L5S1 problem that Dr. Durrani ultimately operates on. And then very shortly after surgery, the plaintiff here is assaulted in a situation where her back is injured, and then and then falls down a flight of stairs. A few months later, her back is injured again. So we think this is a very close case on the facts where the unfair prejudice of the evidence that came in would clearly tip the balance against Dr. Durrani for unfair reasons. But jumping to the absence instruction, this case had a jury instruction that read as follows. You are allowed to consider as part of your deliberations the fact that Dr. Durrani did not attend trial and testify to specific facts about this case in his defense, and you may draw whatever inference or conclusion you choose from this fact. It's missing the wink in brackets in the transcript, I think, but clearly I think there was a wink from the trial court here. This is a terribly unfair instruction. It is unsupported by any case law. We have this come up from time to time in these briefs. As yet, plaintiff has found no case that suggests that there can be an inference instruction, even one as minor as this, as to the absence of
and I
blame.
guess, like, you say there's a wink, but, like, we don't see a wink in the transcript. And when you say you can draw whatever inference you wish, it seems balanced. And I think, the trial court is responding to an empty chair issue, and the jury's going to draw some inference from that, and this is an effort to at least restrain their inference drawing. So what's wrong with that?
Well, I disagree with the fact that there is restraint here. What it says is you're allowed to, he didn't appear to testify about specific facts of this case in his defense, as if there is an obligation for him to do so, which of course there is not. The instruction is focused on, hey, he didn't really defend himself here. I think
Where
that
did
is.
it come from?
What's that?
Where did this instruction come from?
I believe it came from plaintiff's recommended instructions in this case.
But was it like, usually when you recommend an instruction, it's based on a case or something? It just came out, it was just made up?
We don't find the basis for it
Okay.
in the law anywhere. It's certainly not an OJI.
Right.
It is not in other medical malpractice cases. It is not in case law. The closest thing they cite is something called the Lautensberger case, which had not quite the same instruction. And there it was not driven home. A key difference here, of course, is one of the themes of plaintiff's entire case from opening to closing and everything in between is Dr. Durrani's absence. And then the judge in an instruction drives home, hey, he wasn't here. Draw an inference or not as you see fit. I think, Judge Bergeron, and you were, this kind of came up a little bit yesterday when you mentioned the empty chair issue. It certainly is an issue. Jurors will notice. Jurors spend time, and they volunteer their time. They get paid less than parking and lunch to be there. I'm sure they draw conclusions on their own about parties that don't attend. Having the judge drive it home, which I think is what this instruction does, is particularly problematic.
So I mean, you're telling us that there's no, there's no basis in the law for this instruction. As I'm looking at your brief, I'm not seeing the case that tells me this is completely inappropriate. And like I'm reading, I mean, some of these cases say the defendant's not required to attend trial. Like what if that was baked into the instruction? Like Dr. Durrani's not here, a defendant is not required to attend trial. You may draw whatever inference you wish from that. How's that?
I would suggest that if there's any instruction at all, it should say you should draw no inference from it. Because that's really, I think that's the right answer under the law. Defendants don't have to attend. It may, and we don't get to talk to jurors after, we don't get to use the evidence of what the jury actually thought. We don't get to see any of their testimony. We can't actually know what they think about these things or not. We use our common sense and we say, well, I might be ticked off by the fact that one of the parties didn't show up at something that I was required to.
Counsel, can I go back to the first part of the instruction on I think it's the failure to testify in his own defense? Is that what the instruction says?
It does, and it also says you are allowed to consider as part of your deliberations the fact that he's not here.
So it's both absence and failure to testify.
Yes, yes. And that they're allowed to consider the fact. That's the other thing I should have.
So I think I know the answer to this question, but I just want to make sure. The plaintiffs did not subpoena him to testify, did they?
They may have.
They did.
Okay.
All right, and he did not respond.
Well, he's outside the subpoena power of the court as far as we know.
All right, so the subpoena was not enforceable. It was an invalid subpoena. Was there a motion to quash it?
I don't think so, Your Honor, but I don't know for sure.
You
All
can
right.
navigate the Hague Convention and get them that way.
They could, and Mr. Winter may know that fact of there have been efforts over time, so I don't know specifically in this case if there was a subpoena. So I don't want to tell you with 100% certainty that there was or wasn't. I do know that there are from time to time.
Is there a problem with the plaintiff's counsel commenting on, not the flight? I know that that was a motion in limine, that you couldn't talk about him fleeing, right? But just the comment by plaintiff's counsel on his absence, that's permissible, right? Or
So I don't think there's much case law on that either.
Okay.
But just kind of parsing it out together here, I think you could see circumstances where maybe it comes up in passing, but
he's not there.
It's going to be obvious
Right.
to the defendants. They are going to the jury. They're going to see that the person isn't defending themselves and draw conclusions from that. But here they were told by the judge, you're allowed to consider it.
this is the issue, is the fact that you're saying that the judge is hammering this home in a jury instruction and saying they can infer whatever they want out of this.
Right, after a trial that from opening to closing emphasizes.
And so again, like what is the strongest authority that you have that would tell us that that's wrong, that that's impermissible?
So I would say the absence of case law, the absence of the use of an instruction like
It's
this.
so well settled that no one has decided to state it.
I think I think there is, I understand, I understand where you're going, but yes, I think that's fair, because it is not something that is typically offered, because people see the inappropriateness of it. Judges don't let it happen. And certainly, I mean, we're not in the criminal context, which makes it a little different. In the criminal context, we have particular constitutional protections against it. But the same ideas have carried over into the civil context, which is why you have the cases that say you are not required to appear.
This instruction is allowing any inference, any inference, right?
Yes.
Even impermissible ones, like race-based ones.
Yes, I guess that's right.
And that's another issue you're raising in this case.
It is, certainly. It's come through all these cases. The emphasis on his ethnicity and nationality, we think, are terribly problematic, the way they are sometimes hammered home in these cases by plaintiffs' arguments.
And so doesn't this instruction open the door to allowing the jury to consider its potentially inflamed biases and prejudice? by allowing any possible inference. I mean, there was a lot of commentary and in some cases testimony about Pakistan, him being born in Pakistan, his family owning businesses there, him being educated there, the various internships he had there, in an effort, I think you argue, to raise some prejudices against people from the Middle East.
Yes, Your Honor. Well said. I think that does open up the door, and you've raised this other problem. Certainly.
What about our case that we argued just a few moments ago, where the plaintiff, and I'm blanking on the name, did not attend trial? What if this instruction was rewritten and said you're allowed to consider the fact that both Dr. Durrani and Ms. Jones did not attend trial, did not testify, and you can draw whatever inference you want? How would that be?
It is certainly less of a problem if you're not tipping the scales to one or the other at that point. I do think, though, the judge was essentially, unintentionally, I'm sure, but feeding into plaintiff's entire method of trying these cases when they issued this instruction. But yes, I guess if both parties are absent and the jury wonders why, and you wanted to say, hey, they're both absent, don't draw any conclusion. I would say don't draw any conclusions from it, but could you live with an instruction that said you can draw whatever inference you want? I guess. I think the better answer is, though, don't draw any inference from it. Or to be silent. You don't actually have to have an instruction on this at all.
But counsel can still, plaintiff's counsel can still comment on the absence or argue it.
I could see it coming up in passing, perhaps. I don't think it's an appropriate part of a case, though. It's not evidence of anything in particular. We really can't draw a conclusion. There could be a million reasons why a party doesn't show up, and we don't have side trials about why they are here or not. The real issues in these cases are medical negligence and then the other allegations they make around these surgeries. And so no, I would say it's really irrelevant to.
Well, that's what I'm trying to understand is there case law that says that even counsel can't comment on the fact that the defendant didn't show up?
You know, we didn't really explore that.
Okay.
But I think there.
Well, I mean, I think my recollection of this issue in closings is that it's a recurring one, but that hasn't been objected to. So, like, that limits our ability to review these issues in closing arguments.
So I think it depends. I mean, I think under Evidence Rule 103, which now says once a court has made a definitive determination, you do not have to continuously raise the objection over and over again throughout trial. Most of these issues are decided pre-trial, and then of course in the jury charge in this case. And once the judge is letting them make inferences about it, and we have objected to that idea, I think that's sufficient under 103 to be a definitive answer and not require us to continue raising the issue. I'm at my time, so I'll answer additional questions on rebuttal unless there are some now.
Thank you.
Thank you.
The law is real clear that a party's absence from a civil trial can be commented upon.
Counsel, would it have been a permissible inference for the jury to draw that Durrani was Pakistani and fled and therefore was probably involved in something bigger and broader than this medical malpractice case that placed a risk to the United States, and that's why he's out of the country, and good riddance?
I was looking for the pretrial order in this case. That wasn't fast enough, but that is just prohibited. Judge Schweikert entered a pretrial order stating that comments could be made about Dr. Durrani's absence, but no one's allowed to speculate why.
Except for the
I'm
jury.
asking about the jury's inference. Could the jury have drawn, would it be permissible for the jury to draw that kind of inference?
They shouldn't. I
How
mean,
would
if-
they know that in light of the fact that the judge told them they could draw any inference they wanted to?
Because it's just wrong to extol racism in our judicial process.
But didn't the judge just open the door to that by saying draw whatever inference you want?
He can, he also said that you're not to speculate as to why he's not here, but you can consider Dr. Durrani's absence in your deliberations. Like he didn't care enough to show up for trial, that's appropriate.
Didn't he, well, okay, you can consider, he said you can draw an inference.
Yeah.
Okay. Where does that instruction come from? I mean, typically when you give instructions, either it's OJI or it's some case that you cite for the
Those bo-
proposition, and then you craft together an instruction.
That was before I came into this case. That pretrial order was entered, and I think in a slew, you can look at any of these cases.
So would that be, if we went to the record and we pulled, would this be like a written instruction provided to the judge? Because normally you have your instruction and then you have your case citation of where that came from or the
Oh,
proposition.
you wouldn't have anything nice and cookie cutter like that? That'd be wonderful.
That would
if
be
it was.
wonderful.
Yeah.
I'm just curious where this came out of because
I recall, and you see how my memory can be, but in the pretrial order, there is a comment, there, I think it's letter G, and it talks about what about if Durrani is here, what about if he's not here, and if he is not here, this is what we're going to do. And that is, we can state that he will not be, the reason for his not being here it was not a proper matter of discussion. It just isn't, but we can comment upon his absence. And that's Smith versus,
Well, but I think there's a distinction between commenting on his absence
Yeah.
versus the jury being instructed.
well, I think it's a protection for them that they get.
They say they don't want that protection.
Well, then they can submit their own instruction and get a ruling on it. That didn't happen
they
here.
objected to this instruction.
Well, then tender.
They didn't want any instruction. They wanted silence from the judge.
Well,
No comment.
well, the judge didn't abuse his discretion in doing what he did. Both, I mean, that was in the pretrial order, that was what our judge did, Judge Reese.
So telling the jury they can draw an inference
Sure.
is not an abuse of discretion in light of the pretrial order saying that you can't speculate as to why, or comment that he fled, or speculate as to why he
Right.
left.
But he wasn't here, he didn't give a rip enough to show up at his own trial. You can consider that, or not consider that. You just can't say, the jury it would be improper to say he fled because he was under federal indictment, he didn't show up because he felt like he would be racially discriminated against, any of the other reasons that I've heard about Durrani's absence. But you certainly can consider his absence. The case law is real clear on that. I did a better job on citing authority in the Nichols case coming up at page 17 and 18. But that's entirely proper for counsel to comment upon. And then I would think it's not a great leap of faith or judicial temperance to instruct the jury that Dr. Durrani has not been here. This is just me. I mean, they should tender an instruction. If
They
something-
shouldn't have to tender an instruction if they don't want an instruction at all,
Yeah,
right?
Well,
They just
Well,
objected to your.
yeah, and
appeal one.
I think this gets back to the question, like, what is the reason for this instruction to begin with? Like, you're saying it's to help them. They say, we don't want the help. So, like, we have to analyze, is this instruction appropriate under the circumstances if it's purportedly designed to help them and they don't want it?
Well, my colleague is going to make sure the jury gets an earful under Smith versus Lautenberger about why, or about his absence. He didn't even bother to show up. Well,
And they've done that. Like, you all have done that in the closing
we're
arguments.
going to do it again, too, unless you tell us otherwise.
Well, right, but I think like what we're having to evaluate is the propriety of this instruction. And there's a difference, I see a difference between the permission to comment on absence and a specific instruction that allows the jury to draw whatever inference they want, including potentially impermissible inferences.
Well, then the judge should have the wherewithal to rein in things that should not be considered. That's just winter on jury instructions, but you know, that's what that instructions are for. And we need to rein in bad thinking or inappropriate thinking. I don't think was
How
done.
how would he do that? In a
Um,
jury instruction?
You can give whatever weight you have about his absence, but you're not, and repeat again, you're not to consider at all why he's not here.
Okay.
I'm just running at the mouth
Right, but that's
now.
not what
I'm
this,
sorry.
that's not what their problem with this
No,
instruction is.
No. But the judge, I don't think, didn't abuse his discretion on instructing the jury, allowing us to comment. I just want to make one other point. In one of the cases, at the beginning, Mike Lyon got up, introduced himself and his colleague, and said, "Hi, I'm Mike Lyon. This is Paul Volman, and we represent Dr. Durrani, and who isn't here, he's in Pakistan." And as an aside, those words were attributed to my colleague, and but that's what happened. So I don't think the judge abuses discretion on the abstinence, and I have a cross client.
Do you have more time?
No, I don't have one. I think I'm done.
I think you do in this one. At
But
least,
it's case 350. I don't have any other.
no, you're in case 27, 32. The Stratman case, I wrote down you had one,
That's right.
but you did reserve 2 minutes. You're at 9 minutes in.
Well, I'm going to say, while I'm standing up, this is a negligence and intentional tort case. Adams applies. They're not entitled to a set-off, and the two defendants, the defendants and settling parties are not joint tortfeasors under the statute. That's what I got. Thank you.
Thank you.
Thank you, Your Honors. I'll be brief. You know, the cases that plaintiff cites for saying that you can comment, when you dig into those cases, it's a single stray comment. In fact, one of them was just about it was kind of a real party interest case. There was the fact that the real party interest wasn't there. You know, I think it does come back to the emphasis. Mr. Winter talked about something that I don't think is in this record, and I'm not sure what record it's in, about at some time defense counsel standing up and mentioning that Dr. Durrani is in Pakistan. When you know, as these cases go, that this is going to become a major issue, at some point, defense counsel faced with that has to stand up and decide if it's going to take the sting out of something, and it shouldn't be found to have waived or any kind of prejudice. Plus, it's not in this record. I don't know where that comes from.
Were there other cases in this cohort that we have right now where this instruction was given?
I think this is the only one with this specific instruction. I do believe there are cases coming down the road that you don't have yet that have a stronger inference. At some point, the collage stops being used for the courts. My understanding is the collage eventually stops, and there is preference for an adverse inference instruction that goes farther. We're outside the record now. Just something for the court to think about as we go through, as we will have to deal with the fact that there are group trials coming up in these cases. My only point, what I'll say on prejudgment interest briefly, not prejudgment interest, I'm sorry, we've dealt with that plenty. On the set-off in these cases, part of the joint tortfeasor analysis would be knowing what in fact they settled for and what is in those settlements. As with many of the things that have come up in these cases, and as Judge Kinsley has pointed out several times, there's a lack of an evidentiary record to base a lot of what plaintiff's case is on when it comes to these ancillary issues. And that's yet another one. So I just wanted to point that out as well. If there's nothing further, this is my last time in front of you for the next couple days. We appreciate your patience and time. Thank you very much.
Thank you. And Mr. Winter, you did have some time remaining. Did you want to use any of that time?
Take quite a minute. What we look at for purposes of joint tortfeasors is the complaint against Westchester and UC, and you'll see it's the same document that we have against the appellants here.
Well, in this case, I think the set-off was just as to Medtronic only.
Okay. All right, well then, Medtronics is the manufacturer of BMP2 that we've had a little bit of discussion on. Its complaint is not in the record. I just happen to be the attorney of record leading a charge against Medtronic, and those were the claims. They were product liability claims and fraud. I mean, that's what you get to sue.
It looks to me, and I could be totally wrong about this, but it looks to me like there's a common amount in these cases involving Medtronic set-off that's something like $2,607. Don't quote me on the exact number. Was there some kind of global settlement?
There's a settlement. Yeah, we lost in federal court, took it up to the Sixth Circuit, and had a big mediation, and we entered into a settlement agreement, and...
A per person amount?
Yes.
All right, thank you.
That's how that worked. That was, but those are the claims. They were, products liability claims under our Ohio Products Liability Act. There weren't anything other. Well, and there was fraud too. I want to admit, get that in. But they're not joint tortfeasors. Thank you.
Thank you. Well, thank you both for your arguments today. The Stratman case is now submitted. We have one final case today, the Nichols case. Absolutely. Mr. Sayer, would you like to reserve time for rebuttal?
Yes, Your Honor. 3 minutes would be
3
sufficient.
minutes. Mr. Winter, my notes say there is no cross appeal here.
That's
Is that
correct.
correct? Okay, so
There's no cost.
there's no cross appeal. Okay.
So, good morning again. Russell Sayer, arguing yet again on behalf of the appellant. Let's level set things real quick about the collage. There's been some confusion, just for clarity's sake. In this case, it's the 50-minute abridged collage that we're talking about. That's what was displayed to the jury in this case. But as we did with Ms. Green this morning, the first thing to start with is this. Ms. Nichols' surgery was a success. She had been suffering from back pain and other painful ailments for many, many years, since a 1992 car accident by the time she first saw Dr. Durrani in 2010. By then, she was experiencing severe back pain from the neck to the buttocks, along with pain and weakness in both of her legs. After her surgery in 2010, she felt better for a time. And after a second surgery in 2012, her pain was reduced, save for occasional flare-ups, and that improvement was permanent. A good outcome for somebody who had been suffering for many, many decades, or 2 decades. And yet, when she sued Dr. Durrani anyway, the verdict was $26 million in change. We asked ourselves in Green, how did such a thing come to pass? Was there a thumb on the scales that tipped it for the jury or made the jury so angry that not only did it award more $10 million in compensatory damages, but $17.5 million in punitive damages for a successful surgery? The record is replete with possibilities that could contribute to the explanation for that, but let's return first to that 50-minute abridged collage. Although it was truncated, Mr. Nichols' trial counsel still made the most of it in terms of vilifying Durrani as a person, while paying scant or little attention to the medical treatment that Ms. Nichols received. The 50-minute version included questioning about license revocations. The 50-minute version included questioning about other lawsuits in which Dr. Durrani had been involved. The 50-minute version included questioning about the criminal charge. It included questioning about Dr. Durrani's absence in Pakistan. It even included questioning that can only have been intended to appeal to ethnic and religious animosity. In other words, the collage was the vehicle for plaintiff's counsel to testify in the form of leading questions about unflattering but irrelevant aspects of Dr. Durrani's life. As we did before, we can start and finish in the same place. There was nothing whatsoever in the collage, the abridged collage, about Dr. Durrani's treatment of Ms. Nichols or the treatment of any other patient. Trial counsel, plaintiff's trial counsel, made up for the gaps in the tape, in the truncated collage, by pulling out the stops in their remarks to the jury in closing argument.
And were those remarks objected to at closing?
Your Honor, I don't have that information.
Counsel, isn't this the case where plaintiff's attorneys in closing commented that the Durrani's experts were themselves from Pakistan and that was crazy?
That's just where I was headed next. The counsel told the jury that Durrani should be held to a higher standard of care than an ordinary surgeon because of his advanced training. Counsel appealed to the jury's passion and prejudice by telling them that they needed to step into Ms. Nichols' shoes when considering non-economic damages and observe the degradation of her entire life. Those sorts of do unto others or so-called golden rule arguments are prohibited in closing arguments by State v. Robinson. Piling on further, counsel violated evidentiary and ethical rules by vouching for the credibility of witnesses about Ms. Nichols' husband. And that man sitting there is one of the most credible witnesses I've ever seen. About Dr. Bloomfield, one of plaintiff's experts. I don't know how you could get any more credible than Dr. Bloomfield. And how do you argue with that credibility?
So were there objections to those comments?
As I said before, Your Honor, I do not know.
Well, I mean, but that's pretty significant because these comments violate the rule against vouching, as I understand it. So they wouldn't be subject to some pretrial order because you wouldn't have expected that. But when counsel hears a lawyer vouching for the credibility of witness, like, they need to object to that. And if they don't, then it's waived or it's plain error.
I don't think they did object here.
It's a simple matter to check the transcript.
Yeah,
We can do
that's,
that.
that's my understanding, is that there were no objections to these issues.
And if that wasn't enough, the council made disparaging remarks to Judge Kinsley's point about Dr. Durrani's experts. Dr. Durrani's experts would, quote, only perform for cash. He's a circus barker. He's a drifter, roping people into cash deals for surgery. As to the non-white experts, non-Caucasian experts, we somehow got 2 doctors from the royal family in the Middle East, one in Saudi Arabia and one in the United Arab Emirates. You believe this stuff? It's craziness, just completely like made-up craziness. That strikes me as plain error. Coupled with the remarks about Dr. Durrani's absence, his ethnicity, this could only be characterized as an appeal to the worst sort of bigotry, and goes a long way towards explaining what can only be described as a runaway verdict. There's another example. You can look at the future damages award. The absence of evidence of future damages, medical expenses, is a topic we've visited frequently over the past 2 days. The jury here awarded $3.1 million in future medical expenses, but there was no proper testimony to support any award of future damages, and certainly not one of that magnitude. Dr. Bloomfield predicted that Ms. Nichols might need pain management, but offered no opinion as to the cost of that treatment. Ms. Nichols' trial was 7 years after her surgery. If there were to be future medical expenses, surely 7 years would have provided enough data to support some testimony, some evidence on that point.
But I also think, like, at some level, and I asked this question in one of the earlier arguments, like, you're the defendant, you realize this time gap, you realize future medical care is going to be an issue, you serve interrogatories and document requests on the other side, and if they don't respond, you ask for sanctions from the trial court. Like, how, like, whose fault is it that there's no evidence here?
Well, all of that's true, Your Honor, and you could certainly criticize trial counsel for not making that request if they didn't, but it doesn't change the fact that the evidence wasn't proffered by the plaintiffs. That has to be done. Whether the defense counsel did the work of plaintiff's counsel or not and insisted that all of the evidence upon which they were going to base their case or base their claims was made.
If the plaintiffs don't put forth anything, then why would defense counsel bother anyway?
There's nothing to do.
Right.
You know, one of the things, all of your honors have been in private practice, one of the things that we know is we don't know what we don't know. We don't know what isn't there. Sometimes we don't know what to ask because we don't know what's out there. And that does happen. I don't know that that happened here, but it certainly can happen. And it ultimately is the plaintiff's responsibility to offer proof of their claims. It is not the defense counsel's responsibility to make sure that the plaintiffs have provided all of the evidence that they should use to support their claim at trial.
Did these experts even put out a dollar amount at all?
One expert opined about the possibility, and I emphasize that word, possibility, not the probability, of $50,000 to $100,000 in future expenses. I think for medication, that's a tiny,
Is that
tiny
pain
fraction.
management?
Pain management.
Is that aggregate or like an annualized amount?
It was presented in a somewhat ambiguous way, but it reads as aggregate.
So but his testimony was that she possibly would need this, not that I
Possibly.
predict that she's going to need this amount of money in pain management.
Yeah, and we all know the standard for the admissibility of expert testimony. It has to be presented with reasonable certainty. I suppose you could talk me into thinking that somebody predicting that it is likely, or I predict that this will happen,
Likely would help.
might be characterized as reasonable certainty. I think I would argue otherwise, but certainly telling the jury that it's possible that she might need pain management, and that could cost $50,000 to $100,000, does not come close to establishing or reaching the minimum standard for the admission of expert testimony. For that reason, the only conclusion that we can draw here from the $17.5 million punitive damages award, $3.1 million in ephemeral phantom future damages has to have come from a jury that was inflamed by anger or passion, because it can only have made an uninformed guess. Somebody told the jury that there's a possibility of $50,000 to $100,000 in future medical expenses in this case. And the jury, seemingly disregarding that, assuming that was even proper and competent evidence, returned a verdict of $3.1 million, exponentially higher than even the faulty evidence that was introduced at trial. What could the jury have done here other than speculate? There's no other explanation for it. This is perhaps one of the most illustrative examples of how the collage and the comments of counsel about what was in the collage and, for example, vouching for witnesses, criticizing the other witnesses, it builds on itself, and it results in a situation in which we have a verdict that cannot be explained by any rational process and can only be explained by a jury or a group of people who think that this is a man that needs to be punished for a successful surgery. Somebody she underwent 2 procedures with Dr. Durrani, and after the second procedure, her pain relief was permanent, and that was worth $26 million. That can't possibly be right, and I see that my time has lapsed. I hope I still have my...
You have your rebuttal
few
time,
minutes.
yes.
Thank you, Judge.
Thank you.
Well, it's true the jury awarded $3.1 million for future medicals and care expenses. That can be, she was permanently impaired by Dr. Durrani. Dr. Wilkie and Dr. Bloomfield testified extensively as to
Where would they get that kind of number from? Like, how would they do the math?
I
to
would,
come up with that?
well, $200K up front. I mean, there's a revision surgery that's needed.
For 200,000?
Yes,
How do we get to, I mean, where does the rest of the 3?
that
Million.
comes from Dr. Wilkie, or was it Wilkie? It's future pain management.
I know in some of the cases, there was this actuarial computation about
Yes.
remaining lifespan. Did we have that here?
Yes.
How
Well,
many years was she expected to live?
Yeah. She's going to live, she's another 32 years to live, has been permanently injured by Durrani and cast, will live those 32 years in constant pain, and most importantly, will require constant pain management treatment. And that's
Who said that?
100,000, I'm sorry,
That you're quoting who?
I am quoting, let me get the right one. Bloomfield,
So
Volume 3, page 4.
so the quote that you just read says she will require future pain management, not
Yeah.
that she possibly will require future pain management?
Let me give you, let me give you a better quote. It's on page 27 of my brief, but Bloomfield testified she will require future pain management approximately caused by Dr. Durrani's 2 unnecessary surgeries. It's Volume 3, 421. And then that the underlying numbers come from a review of the pain management specialists that are in record in the as exhibits, And I can't give you those numbers, I'm sorry. but
So we
they were-
look at the bills, the pain management bills to
Yes.
get to the amount that that's going to cost?
Yes, and it's a $100K a year.
All right, so that gets us to 3.2 million, and then where do we get the rest of the money from?
I think 3.1 was what was offered.
3.1, all right,
And I think we're there, Judge.
all right.
And that's where that comes from.
Mr. Renner, can I ask you about
Yes, sir.
the closing argument? I have to say, I'm really troubled by these two statements. That man sitting there is one of the most credible witnesses I've ever seen. I don't know how you get more credible than Dr. Bloomfield. I mean, that's like trial practice 101. You cannot vouch for the credibility of witnesses. How is that appropriate?
Was there any I didn't read that part. Was there any statement about what Bloomfield did or said on the merits of attacking the work of Dr. Durrani? Not necessarily.
But like, I don't understand, like, you're not supposed to vouch for the credibility of a witness. You're not supposed to insinuate personal knowledge, which is, I know this guy, I trust this guy, he's credible. And to say something like the first comment, like the most credible witness I've ever seen, seems to be going across the line there.
That doesn't advance the ball down the field for us, I don't think.
Well, yeah, but like, what do we do with that?
That's I mean, those are darn few I mean, that's a bad comment. I don't know if I was objected to. My notes.
Well,
say
that's a problem, right? I get that.
And my notes say that it wasn't objected to, but I don't have a cite to them.
Even if it wasn't, I mean, I don't think it was. So,
Yeah, that's my recollection too.
okay.
And then what about the comments and closing argument remarking on the ethnicity of the defense experts and calling that craziness and not believable, simply based on the ethnicity and country of origin of
Yeah.
the defense experts? I mean, that's not proper, right?
Right, yeah.
What do we do with that?
Wasn't objected to. Dr. Ciani is also, our neuroradiologist is not a Native American. I'm going to use the wrong word, American citizen.
Well, they're saying that those experts, I thought what defense counsel said was that plaintiff's counsel said these were experts from the Saudi royal family.
Oh, Dr. Durrani treated members of the Saudi royal family.
Okay, I'm getting confused. I know that was asked in the collage, but I thought in the closing they said the experts were actually from the Saudi royal family.
Oh, well, we have a lot of friends, we don't go that far. No,
Okay.
Your Honor. No, Your Honor. That's the only reference to the Saudi royal family that I was aware of.
So you agree that these were improper comments, but your response is they didn't object?
And, yeah, and where's the harm? The jury entered a significant judgment, but it was rendered
Yeah, I see
contrary.
like a direct line that your opposing counsel is drawing between those comments and
Yeah,
this large award.
But I mean, when taken as a whole, the closing dealt with the medicine, not the man.
But talk about that though, because did this patient get better after the surgery?
No, she's got 32 years of life to go and has pain management for the rest of her life. It was caused by their doctor,
Did she have pain management before the surgery?
perhaps some. but not 100K a year. It's constant. No.
Didn't Dr. Bloomfield testify that Ms. Nichols was happy with the results that she received from Dr. Durrani? And wouldn't the fact that she went back to him for a second surgery suggest that she was pleased with her results?
It goes to Dr. Durrani's ability to talk people into surgery.
Well, what about Dr. Bloomfield's testimony? I mean, he said that she was happy with her results.
I'm sure in the short run they were. There are several folks that you'll be seeing over the next term where they were happy, and then kerplunk, it falls off the cliff. Maybe the painkiller medicine runs out, the surgery fails, one way, shape, form, or the other. And one other, okay, did I answer the question?
Yes, thank
Okay.
you.
I mean, and one other thing, you know, the Tort Claims Act worked here. I mean, that punitive damages worked. It was capped. The system worked. They don't like the future meds, but there is no cap for that. We proved it. I can't recall any others items that were capped, but the punitives comes right out. Yes, the comments were not appropriate. I have to deal with that in the future. Oh, and I didn't have a cross claims. Thank you, judges.
Thank you. Mr. Sayer, you have your rebuttal time.
Thank you. May I return briefly to the question of whether the testimony was objected to? This has been a long process. There have been many trials already. There will be many, many, many more to come. At some point, I think trial counsel is worn down when it knows that the same misconduct will be allowed in every case. That's what happens in a case like this. But there's more. Under the Ohio Rules of Professional Conduct, a trial advocate must not assert personal knowledge of contested facts, state a personal opinion about the justice of a cause, the credibility of a witness, or the culpability of a civil litigant. That's Ohio Rule of Professional Conduct 3.4c. Trial courts, it has been held, for their part, must react swiftly and indefinitely to prevent such conduct. The first duty here was the duty of the trial court. If appeals to overt racism are not plain error, I couldn't tell you what is. But that's what was going on here. Sub rosa, but that's what was going on here. Appeals to the worst instincts of people. It's plain error to permit it. The trial court was bound to step in and do something about it and did not. On the question of future damages, I simply just want to clear something up. I spoke in my opening remarks about the possibility of future damages. That testimony came not from Dr. Bloomfield, but from one of his colleagues. What Dr. Bloomfield said was she will need pain management. There's no dollar figure associated with that. Nothing.
For the rest of her life.
He doesn't say. And we don't know that. But that she will need pain management. But you can't just say that without telling the jury or giving the jury something to go on.
Well, I thought they had bills of prior pain management in the record. Is that not good enough to
Well-
look back at how much she's been paying for that?
Her prior pain management, Your Honor, occurred before she underwent 2 surgeries that resulted in permanent improvement of her condition. I don't know what those prior invoices could possibly tell you, about future pain management for somebody who's been largely cured.
So these are bills from before the surgery, and then you're saying what's missing is anything after the surgery?
She was evidently satisfied with the surgery. She reported that the pain was permanently resolved. I don't know how evidence of her treatment years before, and she'd been in pain since 1992. I don't know how pain management expenses that occurred before her problems were largely corrected have anything to do with whatever pain management she was going to need thereafter. It could be as simple as ibuprofen. We don't know. There isn't any evidence of it.
Wasn't she currently under the care of a pain management physician who did not testify in this case?
I believe that's true. And I further believe, stepping for a moment to the edge of the record, that pain management specialist would have testified if he had something relevant to say.
You are at your time. So, thank you. All right. Thank you all for your arguments on this case. The Nichols case is now submitted, and appreciate everybody's endurance. This was a marathon day, but very interesting cases and good arguments on both sides. We really appreciate it, and have a good rest of the afternoon.